Thank you, Commissioner.
We're continuing this first week of the 2-week of public hearings on the priority areas of child protection and criminal justice. But before we start today's proceedings, I would like to invite Commissioner Hunter to do Welcome to Country.
Thank you, Chair. I acknowledge that we are on the lands of the Wurundjeri people and pay my respects to our ancestors and elders, past and present. Acknowledge all those that come before us, so we are able to have voice here today. May Bunja watch over us as we conduct Aboriginal business. Wominjeka.
Thank you, Commissioner Hunter. Council, appearances, please.
Thank you, Chair. I can indicate that
Charmaine Clark.
and you
I do.
and there is a document headed Outline of Evidence of Auntie Charmaine Clark, dated 7.
It is.
I will tender that outline of evidence at the completion of this witness's oral evidence.
Do you want me to start reading my...
No,
evidence,
I'd just like you
to
to just introduce yourself.
Okay. My name's Charmaine Clark. I'm a 55-year-old Wurundjeri woman, turning 56 on the 28th of this month. I'm coming to you from Wollongong on Peak-Wurrung country. I work as a researcher in both family violence and mental health for both Federation University as well as for Monash University and for community various community organisations. I have a passion for working with my mob directly around our healing practices, and I also am a representative for the Southwest on the First Peoples Assembly, and I'm also the co-chair of the Interim Elders Voice with the First Peoples Assembly, along with Uncle Andrew Gardner.
And it's correct that you're...
Quite powerful stories and experiences around family violence. It's a report that I hope will lead to more programs delivered in the area, and also a number of issues that the community wanted raised in that particular field. And more importantly, it's about highlighting and elevating their voices around family violence. Aboriginal communities are more aware. They want to talk about family violence. They're not shying away from it, and they want to actually take the lead on a lot of the programs and delivery of programs around that space.
Thank you. I just wanted to...
I'm a bit of a mature age student. I mean, I left school when I was 16 to start work, as any young kid gets a bit eager to do. So I went to uni as a mature age student and I did a Bachelor of Health Science, specialising in mental health, Aboriginal mental health, and that was with Charles Sturt University in Wagga Wagga.
Thank you. And you've also held positions in the Department of...
Yes, I was the first regional family violence coordinator for the Grampians region when the program was rolled out, 20 years ago. I've been around for a while and I've worn quite a few hats.
Yes.
My CV is pretty long.
Yes. Well,
I actually was liaison officer for all the magistrates' courts across Victoria, but I was based at the magistrates' courts there in Melbourne. Also worked at county court and children's courts as well as the ALO for both of those. So yeah, it was a job.
and you've been...
Review by the Victorian Parliament. They asked for participants. So with Aboriginal Legal Aid and Vic Legal Aid, I was the representative representing the state actually, because I had a case that I tried to pursue around racial vilification here in Wollongong. I did it publicly to try and bring it out in the open. So it featured in a couple of articles here locally in the local newspaper, the Standard, Wollongong Standard. And it showed me all the challenges and failures, I think, of that the current legislation at the time. So I gave my evidence as part of their inquiry.
And that...
These. I want to really deliver on self-determination for us as Aboriginal people. I mean, you can do it in various ways, particularly with my role at the Assembly and fashioning the framework for a treaty process. I know I've just got a consent to recording. There we go. Also, I've been an advocate around reconciliation. I give talks here. I've done smoking ceremonies and welcome ceremonies here in the community. I walk proudly around with my treaty T-shirt on. I get quite a few looks, but also get quite a few, people wanting to prompting conversation. I mean, I want to reach out across the aisle, not the aisle, but across the gap, so to speak, with the general community. I've also been an artist. I had an art exhibition here looking at the history, particularly around massacres. I did an animation piece and also did a spoken words piece as well, and then a healing piece. So, and that was up for about 6 weeks and had a good attendance from the local community and also some interesting reflections by non-Aboriginal people when they came to see that exhibition. So I find as many ways as I can, and many pathways as I can, to try and engage more positive interactions, challenge the status quo, and also strive for self-determination across all sectors. Particularly my research work, I really push in my recommendations that we have the solutions. Aboriginal people have the solutions, the communities do, around those issues, all our issues, and that the governments need to actually cut those little purse strings around our funding and let us get on with the work.
And
that underpin the entire treaty process and its frameworks.
now,
Because the United Nations, the UNDRIP, is what we're actually is our foundational work that we're doing is built on UNDRIP, which is self-determination.
Thank you.
Yes, please. There's also a photo I actually want shown.
Yes, I understood that you'd like to have that photo shown at the end of your evidence, but we can do it now. So it's on the screen now.
Just the photo of my siblings and I.
Yes.
I can't see it though.
No, we've got the two photos side by side on the screen, and the commissioners can see that now.
Well, it's the one that's actually on the of my siblings is the one I actually wanted shown. Thank you. Okay, that's me in a dress. I don't wear dresses anymore. That's me and my siblings. We're at St Joseph's Boys' Home in Sebastopol, Ballarat. We're all wards of the state, and that's the only photograph of us all together, the only existing photograph of us together, because we were separated straight away. These were taken. So I was taken at 2.5 years of age by social workers, along with 5 of my siblings, 4 of them my brothers, and 1 sister. I want to introduce the people in that photo though.
That would be wonderful if you could.
Yep, so from left to right, or my left to right, starting with the young fellow in the shorts and the yellow top, that's the second youngest brother. His name's Peter. The next is my beautiful baby sister, Selena. He is deceased. The next at the front is the youngest brother, and that's Laurie. He's embarrassed by this photo, by the way. Then there, behind him is the eldest brother. His name is Paul. He suffers from schizophrenia because of extreme child abuse. Next is me in a dress, and then my beautiful beloved brother George, who I was very close to. He's deceased, died in a car accident at 18. So there's only a little handful of us left. We've already lost 2 of them.
That photo holds a
I don't have these sorts of memories, these things that they can hold on to. I'm very lucky that I do.
even that single photo is something that other people don't have. Is that what you're saying?
Yeah.
Thank you. We will tender that photo with the outline of evidence at the completion of the evidence. Now, if we can take the photo off the screen, Auntie Charmaine.
Yeah.
Did you want to talk about your removal from your family?
Yes. So I was taken at 2.5 years of age. Now I know this evidence because I got my file. I don't possess it anymore because I've abused so much, so I'm actually applying for it again. But I have read through it some years ago, and some very particular things stood out to me. So I was taken at 2.5. My parents, Eliza Elizabeth Saunders and Lawrence James Clark, my father, were itinerant. They followed the picking seasons. And they had us little ones in tow, so to speak. So they came back from the Murray picking season to Melbourne to stay with family, extended family, and immediate family at that. And had some R&R of their own, of course. And the welfare did a check. And they deemed us as the reason for removing us, without informing my parents, by the way, was no fixed abode. So it wasn't like no fixed abode. That's a pretty interesting sort of reason. Don't have a fixed house is what it actually meant. That's the only reason you took us and didn't tell my parents. We were taken without my parents' consent. We were taken without them being informed either. So then I was taken to, we're taken to an institution there in Melbourne. There is an existing photograph of me of there, but I've lost that as well because we move around a lot. And then we're transferred down to Ballarat. Once in Ballarat, we were separated. The boys, one section, girls in another. Laurie had not been born as yet. When he came later, when he was born, he was immediately taken. I didn't see my brothers. I probably see my brothers occasionally waving at each other from balconies and various other things. But then at the age of 5, at St Joseph, you age out. So then you get transferred to Nazareth House, which I was. So then I was further separated from my siblings. So I was aged out at 5 and then sent over to Nazareth House, where I lived without my siblings, didn't see my siblings, didn't see Selena, my sister, for a whole year. I didn't see anybody for a whole year until she then turned a particular age, because she's only a year younger than me. And then she was then transferred, and that's when I finally got to be reunited with her. It wasn't until I was about 6 or 7 that I finally got to see my parents. And I'll tell you, that was a remarkable day. That's burnt into my memory. The first time I got to see my parents, the nuns came and said, "We've got a surprise for you." They took myself and my sister, Selena, aside. "We've got a surprise for you." We're going, "What is it? What is it?" And they led us down this corridor and then took us into this room. And as soon as they opened up the door, there was these 2 absolutely beautiful, well-dressed, beaming ear-to-ear faces, smiles on their faces, Aboriginal people, adult people, and I knew straight away, and I ran to them. I ran to them yelling, "Mum, Dad." And we cried, and I thought I was going home, but I wasn't. But it was the first time, so we ended up, my parents then ended up negotiating with the welfare to be able to take me out, me and Selena out. Selena didn't react very well to it. She'd already been taken out for visits or weekends by a white family, and she'd started bonding with them and identifying with them. So when she did see our Aboriginal parents, she freaked out. She had a bit of a crisis of that stopped making sense to her. She said, "No, that's not my mum and dad. I've already got these other people where I knew. I've been waiting for them." So, I got to go and at least spend, I think it was Easter with them. It was the best time. And that was the last time I ever got to spend time with them. Because as much as I held on to the dream of my parents, I ran away at 14. I have in my testimony, I ran away at 14 because I had to. Because that's when my father died. And when he died, the dream of us ever getting back together went with him, died with him. So I ran away. I said, I can't do this anymore. I can't wait anymore. Because when the dream's over, the waiting's over. So there's a lot of trauma and stuff that I had to cope with during that time in care, ironically called care. Abuse from holiday parents. One particular holiday parent, I could not understand why she was a Catholic woman, a Catholic family, used to come and get me and take me to Horsham. That's where they resided. And it was like I was some little pet. She'd show me off to her friends, this little brown girl, little pickaninny. And she'd make me do things that really made me really quite uncomfortable. And one in particular thing I'll never forget was that for some reason, even though I was only around 7, she made me swim. She insisted that I get my certificate of the 50-metre pool swim at 7. And she, while she was cheering, she had all her friends, all her white friends, they're all cheering me on, and I'm almost drowning. I'm saying, I don't want to do this. I don't want to do this. But I had to do it because I knew she'd be mad if I didn't. So I did it, even though I've been terrified of deep water in the since. She also didn't like me forming an attachment to her. She had 2 other daughters, they were wonderful, and a husband. He was fairly supportive. But I was her project. But she didn't want this project, this child, forming an attachment to her. I mean, her kids could bounce around the house, saying mum this and my mum this and mum that, but not me. I said mum because I was slipping into the vernacular of kids, and I was forming an attachment to this woman. And she said, she then said, I'm not your mum. And then I called her mum once too often, and so she just grabbed me by my arm, dragged me to the bathroom, pulled out a hairbrush, bristled down, bare arm, and then proceeded to hit me across the bare arm, drawing blood because the bristles are breaking my skin, and then saying to me, repeat after me, you are not my mother. So she'd go whack, 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 and I'd have to say, you are not my mother. Then she'd whack me again, say it again, you are not my mother. She said, no, don't forget that. There were other abuses that she did, physical abuses, which I don't want to go into detail of. But it really scared me off people, especially white people.
Yes.
Then we were fostered out. And it was Selena's, the people that Selena had been seeing for quite some time. I did not have the same relationship she did. I was 9 when they came, when I got given to them. I didn't want to go. But these particular institutions were starting to close down, so they need to move a lot of the children on. You either went into foster care or you went into group housing. So I went into, I went with Selena, with a package deal. I wasn't welcome there. I remember my first day there, getting a suitcase out and whatever else, and being told by, I think it was their niece. This is a much more mature family, so the parents were in their 50s, mid-50s or so, and they had adult children living at home. So the youngest adult child was 18. I was 9. Selena would have been about 7.5. And they had nieces and that people, welcoming us, except me, of course. And she came up to me and nonchalantly said, this is not your house. We didn't want you. We had to take you because we want Selena. I said, and we don't want you to forget that. I said, I won't. and they didn't let me forget that the entire time I was living there. I was given separate brushes. I was treated very differently, indifferently. I was also psychologically abused and also sexually abused in my time there. But whenever my parents would come and see us, it was this huge, dramatic thing for these folks. And we'd spend time with our parents, half a day or so. But whenever my sister and I come back, we'd be sat at the table and interrogated by them. Interrogated by what our parents said, everything. And then they'd have their own discussions about how they looked, quite disparaging, constantly disparaging my parents, constantly disparaging Aboriginal people. Quite frankly, they were bigots. And that's one of my criticisms as well, is that they don't vet people appropriately. Because I've said to some horrible people, frankly. And I'll never forget a day too, when my parents came to see us, and the young 18-year-old answering the door was my dad. This hat, dad beautifully groomed, both of them beautifully groomed, hat in his hand, took it off, sort of begging, asking permission. I'm standing behind her and watching, asking permission to see his children, of an 18-year-old who quite, snobbishly and arrogantly said, "I'll see," and then walked off. And I saw my parents looking really deliberately shamed. It broke my heart watching that. Really broke my heart. It didn't make me angry, it just made me broken for them. So when I reunified in now, when we walk around my parents, that shame translated into my shame being around my parents at the time. I remember once walking down the street and Dad wanted to hold my hand, his big hand, my little hand. I still remember it. And we're walking and I'm looking going, wow, I'm walking with Aboriginal people. I'm walking with my family. Wow, this is my belonging. This is me. But as soon as some white folks came towards us and stuff, and I was looking at them, I then pulled my hand away from Dad and moved away. And it was a reflex of shame. And my dad responded by gently saying to me, "You don't ever have to be ashamed of yourself." And he gently took my hand again, and we kept walking. And that's when it started for me. That's when that fight, instead of feeling shame, I wanted to fight this. So when he died, that's just it. I had to run away. Because of reunification, we were almost there too, by the way. We were almost there. My parents got a house in Ballarat there. They got us all out for the day. They got the boys out, they got us out. And we, for one day, we were under the same roof in our home. Mum, Dad, me, my brothers, my sister, in our house. We ran around the room saying, "That's my bed, that's my bedroom, that's mine, that's mine." We started going bagsies on all the spaces. We started making plans to be a family. We actually almost got there. We saw the finishing line. And then Dad died from a heart attack at 38. And it fell apart. It never happened.
Auntie Charmaine, you've talked in your outline of evidence about being told that you're not like other Aboriginal people. Can you just talk about the effect of that and the circumstances of it?
There's always this peculiarity that you somehow have to impress non-Aboriginal people. Really win them over, so to speak. And it's about that privileging, that somehow them saying that sort of thing, they assume that they're giving you their privilege. That somehow you've earned it, access to it, by being not like other Aboriginal people. And I got that a lot whenever I've had any successes or made a good, reasonable discussion or argument to a white person, both professionally and both personally in my socialising. And I always know that it's not a backhanded compliment in a sense, or is it? It's not really a compliment at all, really. It's a way of people saying, I give my approval, white people saying, I give my approval. And I've seen that sort of affect other Sol and Gen mob, because what it does psychologically is it gives you an either all or nothing, where you either accept this privilege or you reject it. And when you're raised in white families particularly, and you're raised around their environments and such, you walking away from them to join your own family can be perceived as a rejection of them and a rejection of that privilege. And I've seen a number of Stolen Gen who've been raised, because we've talked about it, feel really, really torn between not so much the loyalties, but the identity, one sense of obligation, in a sense. Because that was one of the things, the features of that sort of psychological manipulation from my own experience, was this obligation. We're feeding you, we're housing you, giving you a stable environment. When I ran away and was taken back to them briefly to grab what meagre stuff I could grab, they just completely just said, "You're ungrateful." They didn't swear at me, but they were telling me, lining up, telling me how ungrateful I was, how rude, and what they've done for me and such like that. And you get that sort of psychological manipulation. And it's really quite hard for those who've been raised in a much more loving environment, unlike mine, to connect with their Aboriginal family, while being sort of torn between that and the experiences they've had and bonds they've had with their white family. For me, and also there's some other elements to it as well, and that is identity. People might say, you get existential angst and stuff like that. Humans tend to have that. I mean, at various ages, midlife crisis, etc. But for young Aboriginal kids raised in these white environments, so young, there's identity issues. I went through it, trying to learn about what is an Aboriginal in isolation, through books. I used to experiment. I used to grab books, encyclopedias. This was before the computers and stuff and Google. So it was books. Or I'd watch documentaries if I could sneak around and watch them on TV, because there wasn't, the internet either for that. It was mainly books for me. And I'd drag my sister out into the sandpit and we'd play Aborigines and make up Aborigine games. So, I was always striving to stay connected to my Aboriginality, but I didn't know where to put it. There was no roots, because I was being upheavaled and put into this weird landscape, this non-Aboriginal space. I was trying to find my way through that.
Aunty Charmaine, as a part of finding your way through that, you've sought access to your files and records.
Yes, I did.
And what can you say about obtaining access to your welfare files?
Well, what I did, I actually went to, it was in Ballarat. I went, because that's where the institutions were. And I moved back there. Who was I working? I was working with Department of Human Services, actually. ironically, and I went and got my files, and they actually provided them quite quickly and for free. And when I started reading through it, there were some really some things that really struck out at me. Was the way the welfare officers portrayed my mum. They had some really disparaging comments, which I thought was really, number one, they were extremely offensive and racist. Really, you know, it's really overtones of racism. But the fact they're in files, these are legal technique. This is legal files, you know, and this is supposed to be written by professionals. But these were really deeply racially loaded and opinionated. These were comments written about my mum's character from an opinion piece. They called her a sly fox. Be careful of her. She's a sly one, that one. Now that's opinion. That's slurs and opinions. I think, why would you put that in a file? Why would you write such, you know, and that's verbatim, by the way, such disparaging things? My mum was intelligent. My mum had the mind of a philosopher. My mum was not a stupid person. So, yeah, maybe she got the better at times of some of these social workers, you know, in a conversation as such. But she didn't have the power to change things. They did. So, yeah, if she somehow bent their ego or dented it to some extent, yeah, they put it in their files, because you could see it it was more than just reading between the lines. It was there in the lines, their opinions of her. And they were personal opinions too, which shouldn't have been in there.
And how important was it for you to get access to those files in terms of understanding your own and your family's history?
It's my story. It's you got to know why. I mean, when you're a young kid, 2.5, until I was given by telegram, because I was over in Adelaide at the time, when I got a telegram tell me that I was no longer a ward of the state when I was 17. Had a little celebration. But so from 2.5 to 17, ward of the state. But you don't get control. This is what really frustrates me, is that you don't get to control your life. You don't get to say anything about what's happening to you. You have to be quiet. You've got to let people, you know, the adults take control. I wanted to know why people made the decisions they did. I wanted to know what was their thinking. I wanted to know what my parents were doing, because they never told me the efforts my parents were going through and the crap they were going through, the hoops and the hoops they had to jump through, and the stress on that. I mean, when you're a child and you think your parents, you don't know what your parents are doing, you could come up with all sorts of thinking around that. And I know when talking to my siblings, before we even, you know, finally got out of the welfare's grips, we all had somehow formed an opinion, that a sense of abandonment from mum and dad. And mum copped a lot. Dad had died already, so mum copped a lot when we all came home at various times and had yarns with her. She copped a lot. But when I finally sat down with her and asked, where were you? I heard she was there. She'd never left. They'd never left. They were always there. But what was between her and her kids was the welfare. And they didn't convey to us the efforts they were making. So the file, to me, shed a lot of light on that. Because it's not just my story, it was their story too.
No doubt it is difficult to read the contents of those files with the bias that you've identified in the commentary.
Absolutely.
Was there any assistance to you at that time when you got access to the files to help you navigate that?
No, I didn't. I didn't need outside assistance. The assistance I got and support I got was my siblings. We all got our files, and we all did not like book club, but a bit like that. We all read our files and shared what we shared amongst ourselves and looked at the full picture.
So I just ask you, you've been a strong advocate for the stolen generation survivors, and spoken to many.
As my brother as well.
Spoken to
Laurie.
many other survivors. How important is it for others, from your understanding, for stolen generation survivors to get appropriate access to all their files?
Absolutely. Unredacted, the full, but support as well. I mean, there is, it will re-traumatise. But it's about seeking the truth of your own life, because in there are all the decisions that affected you, that affected your family, and decisions made by people who really didn't, who go on and went to their own homes and their own families and whatever else, and left, and you're the one who had to live these decisions. So it's sort of, for me, was it liberating? I wouldn't call it liberating, not something to celebrate. We feel liberated by it, but it felt that it settled some issues, it settled some grey areas, it gave me clarity. It gave me clarity around my parents, gave me clarity around the system itself. And although there's a lot of information in there that's really uncomfortable and unfair or unjust, it gave me clarity around where and how those things actually came about.
Now,
And we'd seen people's opinions of you too. There's psych reports and all sorts of things in there. How people actually measured you.
later on in your statement at paragraph 27D2, which is on page 9, you talk about, in terms of reform, the need for departmental files to be reviewed on behalf of Aboriginal families. Can you just talk, I just want to take you to that for a second and just ask you to explain that recommendation.
I recommend that, and I'm recommending that because I've worked, two reasons, or maybe three. Number one, I saw my files, the effects it has, because there's power in it. There's a lot of power in it. There are decisions made in those files. There's a lot of leakage of personal biases and racism of each individual person who puts their words and their opinions in those files and their decisions in those files. And there's no vetting of that. There's no sort of, like I know when you work in mental health, you have a supervisor. But when those words affect families and individuals, where's their way of actually looking at that and making sure it's, number one, accurate, correct, and being able to challenge it as well? Because there is power in that stuff. There's power in that, in those words that are put in files. I know that firsthand. And there's a lot of biases that can actually then be set down and then passed on to the next worker and the next worker. Because when you read a file, I worked in mental health, with clients who are long-term, there's files, right? There can be biases that can leak into that particular material. Then the next person who reads it, they pick up that bias immediately, unquestioned, because it's unquestioned, this material. It's supposed to be written in a particular way that has clarity, professional integrity in it, etc. And so it passes on to the next worker or person who reads that file to review. They then pick up that bias as well. And, you know, when you have statements in there that she's cunning, she's sneaky, don't trust her, the next worker is going to read those words. And what do you think? They've already formed an opinion.
And the practices that you saw with respect to recording details about your mother and your father, you've seen that sort of bias repeated in reporting in current day circumstances?
Yeah, mental health particularly, because that's the field that I've worked for about 15 years in, both in the hospital setting. So I've worked in hospitals, mental health hospitals and general hospitals, but in the mental health units. And also I've been a practitioner myself in mental health and also a counsellor in AOD and sexual assault. But mainly it's the hospitals, because these are huge, large systems. It's the hospital systems. I've seen, when with clients, you know, I've briefly looked at someone's file and looked at the particular things in the systems, and they have different little warnings, violent person or whatever else, and I look at that and go, oh, I've got to make sure that this is correct, sort of thing. But for me, generally, whenever I see a client, I don't look at their file. That's the past stuff. I want to see them now. It's now that's important. And then it's the relationship now, and it's how they are feeling now and how they are dealing with it right now. That's the important thing, and that's the focus. Because I've seen a lot in reports, particularly with misdiagnosis. With some clients I've worked with, and I'm going, how did they come up with this diagnosis? Doesn't really match. I've taken it to other colleagues, going, oh yeah, and they agreed with me, you know, like another psychologist or a psychiatrist, I even spoke to a psychiatrist about it as well. And they said, yes, but unfortunately, you can't change it. I said, but that then follows this person around for the rest of their lives. But you can't change it because there's a rule, they don't want to change another professional's. They want to challenge another professional's diagnosis. So the diagnosis just stays there in their files.
And there's no...
So that bias is really quite dangerous. And same with the bias of these whether it's a racist slur or certain innuendos, they're biases that actually do damage.
And there's no capacity in the system at present for challenging those records?
No. There's a lot of advocacy around it, but because they're legal documents, you can't go back and change them.
I might pause there, Auntie Charmaine, and ask if any of the commissioners wish to ask any questions about that particular issue.
So I just need a drink of water.
Maybe if I could just contribute something. The Freedom of Information Act, the Victorian legislation, as does the federal legislation, contains provisions permitting the amendment of personal records. The Commissioner of Information has a power on application to amend personal records, and there are appeal processes in which I've been engaged. I suspect that Auntie Charmaine knows about this, and maybe it doesn't apply, I'm not sure, but I think this needs to be noted.
Absolutely. But also, what Aboriginal family knows that? How are they to know their rights to be able to do that? What I'm saying is when we do, in the practice of child protection and working with a social worker, you meet the family, you do your meetings and such. It should be there that those recordings and that should be at least accessible if asked for. Because you're writing about individuals, you're writing about the person who's in front of you, so to speak. I mean, I work in mental health as a counsellor, and that I provide that for my clients. What are you writing down? what do you want about me? Because it's about power and the imbalance of power and self-determination. There's a lot of stuff written about blackfellas, a lot of stuff. I mean, I did archaeology as well. A lot of research. There's a lot of legislation across the country around Aboriginal people. We're actually the most legislated group in the whole country. And a lot of stuff written about us being the emphasis. I would like to see, while there is that particular freedom of information type thing, in real time, about the relationship between child protection and families, to be in real time more transparent at that level.
Thank you.
Sorry, can I just, yeah, that's right. Aisha, my name's Sue-Ann. Just thinking about, I'm a social worker. So I'm thinking about those, I can relate exactly to what you're saying. My thoughts go back to the professions you're talking about, actually professions that need qualifications. Should we be looking at those universities or those training, and what does it entail? Would you have any suggestions around, or have you had any thoughts around that?
Actually, it's in part of my testimony as well about education. Because with Federation University, we're doing a review right now. We ran a pilot course, graduate diploma in community services, unoriginal, but captures the breadth of what it's about, and it's only tailored to our Aboriginal students. A lot of mature age students actually get it from around the state. But when we were looking at the resource material and stuff, because it was borrowed from another course, and myself and my colleague, we looked at the material, it was all Eurocentric information. It was all source, all the material actually came from European studies, philosophical narrative, processes and narratives and such, and I was like, this isn't particularly nice. I don't like this. So we threw most of it out and just rejigged it with more Indigenous coursework and resource material from Indigenous academics and researchers and such like that. And also made it more culturally safer space for the students to actually learn, have a learning environment in. Because we want people to think and challenge stuff as well. You don't want people just to parrot, and people to bring their own experiences and the reality of their lives into the classroom and challenge some of these particular things as well, which makes a more active learning space. And a lot of the students actually enjoyed that process and the way that we actually worked collaboratively together around a learning activity. The thing with social work is that it's really, it's a lot of theory and such, scaffolding and all those sorts of things. But is there, because there's a lot of Indigenous work out there, a lot of Indigenous research that's been done, and that's my favourite thing is research, because I want to get all this materials and this evidence and such, and our voices into that arena of academia and studies. That needs to permeate into some of these really long, traditional type degrees, like law, like social work. Social work's a very powerful degree. It's a powerful association. They have a lot of sway politically, and fundamentally they are necessary. I respect social workers. I've got actually quite a few friends who are Aboriginal who are social workers as well, Commissioner, and they find it a challenge even doing the degree. Not the challenge as in academically degree, but philosophically and culturally doing the degree as well, as one does with doing psychology degree, because they're very Eurocentric based. A lot of the seminal work is based on the findings from white perspectives. I'm a fan of.
Anisha Main, can I ask whether the difficulties that you've just referred to in the study also extend then into the workplace for Aboriginal people in social work and psychology, to your observation?
Yes, and from my experience, working in being the only Aboriginal person in a mental health unit on staff as part of the staff, and you've got a really distressed Aboriginal client, and that the eyes are darting around and they look straight at you and they lock on you and they're pleading to help them, and you've got this system and this hierarchy. It's challenging, but I do step in and I do advocate, even though sometimes it might not seem the right thing to do by my colleagues. And they're not used to that either. I mean, when I worked over in WA, it was the first time that they were embedding Aboriginal mental health workers in the in the health system. So a bit of a pilot. Actually, it was a pilot really. My job at Narrabeen was the first time it's been done. So we're all learning.
So,
Can I ask a question?
oh, sorry,
Yep.
Commissioner Walter.
I just wanted to follow on with Commissioner Hunter's question. I'm a qualified social worker as well. So, as you would know, the Australian Association of Social Workers is required to approve courses in universities. Universities cannot run
Yes.
their training without this approval. So, what do you think is their responsibility there to actually make sure that these courses are turning out workers, social workers who can provide culturally safe, culturally humble workers to interact safely with Aboriginal clients?
Well, right now, a friend of mine is reviewing University of WA. She's reviewing their social worker course. She's a social worker herself, been 35 years, but works and has worked for years in the field over there in Western Australia. She's doing a full review. They've asked her to, because she's a pretty staunch woman herself. Her surname's a Collard. Is Collard. And that's what I think is a great step. We need to actually go through, because some of this stuff is a little bit creaky and a bit old. And it's not, as much as we understand intersectionality, we've got to go a lot more further than just the theory of intersectionality as well. And actually allow Aboriginal practitioners to come in and actually rewrite the curriculum from an Indigenous point of view.
Thank you.
So I would suggest, is reviews. You're not going to change everything just like that, but it's a good start. And I mean, it's a great experience I've had at Federation Uni, just recently. So this year,
Council,
with
sorry.
working at the picture room. Sorry, Commissioner.
No, I just wanted to go back to Commissioner Bell's point about the Privacy Act and the act he spoke about. I'm thinking about stolen gens and the experiences. I'm not, but I'm thinking about even the experiences you just told us, Auntie Charmaine. So from your experience and trying to get things changed while you're processing it, like, is it accessible? Like, would you, well, not, in your experience of other stolen generation people, is it accessible to get things changed about your mother or your father or yourself or your, like, is that another traumatising process or?
It is, but you've got to, just because something's traumatising doesn't mean you don't do it.
But you're a strong woman and I'm thinking about.
Yeah, no, I understand that, but it doesn't mean you don't do it. You find ways to actually make it safer for the person. For me, I had to, because I had to understand what was going on, and I wanted to be able to tell Mum, have the full story. And
Sorry, Auntie
understand.
Charmaine, I was talking about the changing of documents, of case notes, for example.
Oh,
Yeah,
right.
and how accessible that would be to, I'm thinking about the Act, it's obviously great if you can do it, but as an Aboriginal person who's been through what you've been through, is it accessible to do?
Well, okay, there's two things to this, Commissioner, sorry to respond so quickly. One is past tense, so I can't unwrite what was written.
Yep.
But it's the process of, number one, fostering a better relationship between Aboriginal families and the welfare system itself. The practitioners need to foster a much more better relationship. This can be a part of that, and that is about being transparent as well. And it's about developing a co-authorship of what the work's going to be, where they, I've worked with communities like similar to here in Victoria, but over there in Narrogin, a little town, and population of 600, Aboriginal mob of 2,000, and vulnerable families program, where you co-author. They set the goals and such. So it's about, we need to shift the relationship from this leaning too hard into one's legislation and authority to where it's actually more around like community justice type, a community sort of relationship where actually you're working side by side with each other, than one having more power and one being with less power and privilege. And that sort of transparency stuff can also correlate with, right, so can I get, whenever I do counselling, I always, you say back to the person so you actually have a clear understanding. You say back what they said. So as I hear you, did you say blah, 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 blah? Is that correct? And they either confirm or say, oh, no, it's not. So it's about having absolute clarity as well, better communication and understanding, and also having more collaboration than advocate, and then this sort of, me against us. It's about, let's shorten that gap that is between the work.
Thank you.
Did it make sense? What I'm trying to
Yes,
say?
Yeah.
yes, thank you, Auntie Charmaine. Just following on from that, do you have any view as to where the current state of the relationship has originated from with the department? I think you said looking down on the families.
I've worked with a lot of departments, bureaucrats. There's a lot of power. And it's not just individual, it's systemic power. When our govy cars, I've been a public servant for, we're both state and federal, so I know what it's like to be a public servant and the power that comes with that. We're human, we're all human, but it does, whether you like it or not, you have privileges. And you walk into a room, you walk into a meeting, you're walking in with your title and the entire institution that you work for behind you. And that is so obvious, especially to families who are called to these meetings, and they know that what's behind them, that they're just this family. And here comes the department.
Now, you've in your statement you've made a number of observations about your concerns about the child protection system. I just want to take you to some of those. That's okay.
Okay, and whereabouts was that?
So, paragraph 13. Paragraph 19.
19.
Yes.
Scroll on my tablet here. Key concerns about child protection system, yep.
Yes.
19.
And then in paragraph 20, you list out some of the particular concerns. First of those is the lack of Aboriginal families and children being fostered into non-Aboriginal families. Can you just explain your concerns around that issue?
Well, I know that there is a real lack of Aboriginal families. I mean, there's this huge call-up for, constantly out there by ACCOs and stuff, trying to encourage families to be carers and such. When I was in Darwin, I was a carer. For a while, I loved it. It's hard. It's hard, they're just, it's really rewarding. But we also went through the training and stuff, which was interesting. I think training for carers and that needs to also be reviewed as well, or at least have a lot more of a cultural lens put over it as well. But I know there are roles actually being advertised now for people to Aboriginal practitioners to look at that as well.
So
yeah, we need to provide greater incentive for MOP to participate, to put the hand up to be carers and foster carers as well. A lot of families, statistically, we know that the facts are out there. A lot of families are already struggling. They're impoverished. They have overcrowding issues as well. They have and the poverty component as well. And so it's a big ask. And I don't think it's because we don't want to. I think it's more around what capacity there is. And we need to build capacity for communities to do that, to be able to be a part of participate more in putting our hands up to be carers and foster carers. Because I don't think there's a lack of wanting to. I think it's just it's money around capacity.
Thank you. The next point I want to take you to is an observation you make about antagonism between government departments and Aboriginal community-controlled organisations, and you've said that there's disparities, and you've suggested that there's some bullying type relationship.
And that can come from, as I said, the systemic nature of power. I've got the whole government behind me, and to be able to lean or leverage your way through a particular, through your way of doing it in meetings and such, that leave both even the advocate a little bit feeling somewhat bullied. Also, when it comes to the pointy end of certain engagements around child protection issues with families, it's the one with the most weight behind them that gets their way. Which shouldn't be the approach or the response to the pointy end. Because then you're just pushing families. They're not with you anymore. You're just shoving them along. You're behind them, shoving them, and you're also re-traumatising families. See, we tend to think we know what's best because I did it with this group, or I did it with that family, it worked with that family, it should work with that family, or this is my way of doing things, that this one size fits everybody, and it doesn't. Every family is unique, but also we're not focusing on people's strengths as well and giving people appropriate time. There's always someone's timeline, and it's never really the real timeline, but it's somebody, and usually with departments and stuff, they need to close off cases. They need to have it done in a particular timeline. So that as well comes into the mix. There's all these little things that come in that builds up the social worker interactions with the family. It's really loaded.
You've mentioned that there's an over-reliance on the legalities or formalities.
Yeah. And that's around, who's going to do what and such like that. And this is from anecdotal stuff and talking with those who work in that space here. And also observing their frustrations when they come back from meetings with department.
There's another observation you've made in relation to Aboriginal community-controlled organisation staff not being paid on par with government officers?
Well, they're not. None of us are. The ACCOs do an extraordinary job with half the budget, basically.
And is it-
Yet we're the one on the ground living it every day. I know that there's a lot of upskilling now. A lot of ACCOs have gone through it. Their staff actually have undergone courses, etc., which is fantastic. So, it's not as if academically, because that was an excuse before, or not necessarily an excuse, but that was some of the reasons why people were not necessarily paid what I feel is appropriate. But there's a lot of skills there and experience, and this is their community. These are their extended family, some of them, or most of us actually. We're working with our own people. So we know these things. We know what's, we're intimately, there's much more intimate knowledge around the issues for the families. And we do a lot of work that isn't necessarily called it on paper either. And they do a whole lot of other ranges of things for the family than just what's the title. Titles are just, what you get paid. But the work is actually everything else that you don't get paid for either. And the fact that governments, here we're at a table with a social worker who's probably on, $90,000 to $100,000 or whatever, and there's the equivalent is on 54 or 45 or whatever. It's really unfair, and it's actually, I think, really makes it. It's unfair in a lot of ways. Number one, it really doesn't respect the work that they do. Number two, we're doing some loads. They do a lot more load of all other stuff that these other professionals don't do. And also, there's a lot of burnout in that space for our workers, and it's hard to retain staff, or even encourage young people to get in, come and work for us in this field. So to attract and retain is absolutely difficult.
And that's because once an ACCO has trained up somebody, they're then poached by government?
More than likely, yeah. And not necessarily just poached either. Families want to, you get a career and stuff like that, you're passionate about it. You want to, earn more money, and you have the opportunity to do so now,
So
they have every right to pursue that.
Sorry, Council. Chair wanted to ask a question.
I just wanted to ask a question about review, if I may, Charmaine, and thank you very much for your testimony. It's very moving, and it's very hard to hear your personal experience.
Thanks.
In the first person like this. I just want to go to the point about review. You've talked about an individual social worker doing review. You've talked about different kinds of things in relation to the pay, the status, the authority. My question goes to, are we, through these existing structures, collaborating with the status quo in that people are used within these organisations to participate in some agreement, whether it's through interdepartmental committees or through Aboriginal frameworks to the government. Do we need to change that kind of concept of review, consultation, agreement, and then a new program? Do you think?
I actually like where you're going, Commissioner. I actually agree. I think let's seek a bit more autonomy from that space and actually have our own authority as well in that space, but autonomous. And one that's actually more grounded in Indigenous practices of healing and various other things. They do actually have, I know in the mental health space, they have really interestingly, in Western Australia, integrated both the existing European style practice around mental health, but they've brought in quite strongly put it in put legislation around it, policy around it as well, an Indigenous way of seeing mental health and practices around that as well in the Department of Health up in the Kimberley there, where they actually have an actual ward, a mental health ward, if you want to call it that. It's completely redesigned. It doesn't look like a mental health ward. It actually looks like one would be in someone's home. So it's more about having an environment that's not too foreign for, and it's for indeed the Aboriginal mob to reside in. And it's only mainly staffed by Aboriginal staff, who are bilingual, multilingual, etc., and also have a cultural understanding around mental health and the way that's perceived and perceived by their Indigenous people themselves. So they've integrated it, yet it resides in a hospital, but it's really almost like bringing the outside in, bringing the culture really very much in that particular facility and embedding it there. And that embedment is not just what the place looks like, but staffing, its policies, and its practices as well. We need to look at maybe some similar models of that sort of idea in the welfare space as well, bringing more Indigenous. I know we're almost trying to get there, but we're still coming through that same door.
Yes.
We're going through that same door. It's not that door we should close that door nice and quietly and create another door for ourselves. One that comes through our culture first.
Absolutely. Thank you. Thank you very much.
Just on the issue of practice, Auntie Charmaine, in your statement you talk about there being an obvious lack of reflective practice. Can you just explain what you mean by that?
Well, it's my bias there. No, it's actually my pet hate is when people don't actually do that. And that's in reflection to how some of these notes that I've seen, case notes written and the interactions I've seen, and even just at my file too. We all know, and knowing that a few of the commissioners are actually practitioners themselves, we know exactly when we say reflective practice what we mean. And that is checking your biases, all of them, including we all have it, whether we want to admit to them or not. And that is something that should be constantly done on a regular basis. Once you put something in writing, on a document, in a file, you can't just go back and change it because that's illegal. And it's permanent then. So some may feel that when you feel frustrated or whatever else, I don't think there's enough of that reflective practice by practitioners when they're trying to, and I'm talking about non-Indigenous practitioners, when they're dealing with Aboriginal families and they think that when they think, oh my God, I've losing a little control here, because they need to hold on to that control for some reason, have the authority still. They need to actually, if they're starting to have those reactions, they need to do a lot more reflective practice. And I think that should be part of the, that should be something that, although we're told that's what we should do, it should be something that should be a constant thing. It should be part of their supervision, it should be part of their education, and it should also be part of, I think, a review. If you're working with an Aboriginal family, I think the practitioner needs to also undergo cultural review on a regular basis.
Thank you. I might ask you to turn to paragraph 20, subparagraph B, and then subparagraph Roman numerals 9, which is on page 5 of your statement.
B, Roman numerals 5, yeah.
9. Roman numerals.
Oh, sorry, 9. Yep.
Starts with the words "in a nutshell."
Yeah, the IX, because X means 10. Renewals, 1 is the I. So 10 minus 1, yeah.
Yes.
I learned how to run renewals when I was a kid.
Yes.
Catholic.
So
Catholic.
if you could you just read that paragraph for us?
Verbatim, yeah, okay. In a nutshell, my view is that the department sees blackfellas as simply too much trouble and too complex a problem to deal with. Anyone who has worked in Aboriginal affairs knows the burnout rate is pretty high. Some become overly cynical of the work, while others take on a saviour approach or have a superiority complex and believe they absolutely know what's in the best interest of Aboriginal families. These departmental workers don't realise that it's not about what is best for that family, but that it needs to be led by the Aboriginal family, consistent with self-determination principles.
Now, in light of the question asked by Chair Burke about having an Aboriginal system or door to enter into, do you see that many of those complaints or observations about the failings of the system could be alleviated by that Aboriginal door?
Yep. Also, checks and balances should be also independent and Aboriginal. So if you ever, and this is only going to be applying to when they're working with Aboriginal families. Right, so it's not going to impede anything else, but when they're working with Aboriginal families, they have to go through a particular process. It has to be different. There has to be certain checks and balances, and the power isn't residing completely with them. It's shared, and the responsibility is shared as well. But who leads it is the family. The family is at the centre of this, and they are the only concern, and they are the most important people in the room, not the social worker, the family.
Thank you.
And the child. Yeah, thank you.
I just want to take you to some of your comments around health and education. You've already given some evidence in relation to the training of welfare students. I just want to ask you for your observation in relation to the medication of Aboriginal people.
Clients and people, yep. I worked in, this is from my experience in observations, working in mental health over in Western Australia, in the hospital system. My clients, I observed when I was based at Greylands, which is appropriately named Greylands. I think it's the last existing mental health hospital in Australia. It is going to be closed at some stage. Beautiful grounds, but horrible history. Horrible history. It even has a cemetery there, and there are quite a lot of Aboriginal people buried there who are patients, because that's where they died. They were incarcerated. They lived there and medicated to the eyeballs and died there. So they're buried there as well. Now these are mobs that come from not just urban Perth, but they come from all over. You know? These are people come from remote, semi-traditional communities. English is not their first language. But the observations I made in regards to the medication is that, and working in that and spoken to other colleagues around this, because it's observed by them as well, is that there is a particular sensitivity to medications. And because we already have existing chronic conditions and diseases, when I was at Greylands there, one of my colleagues pointed out, you see that there? I said, yeah. And there's a mob walking around the most distended, huge stomachs. Like they're fully pregnant, male and female. Like they're 10 months pregnant. They said that's the medication doing that to them. And they've all got diabetes. They've all got diabetes because of medication. They're all in their 20s or 30s. And they won't live long. They won't live to 40. And it's not just, and it's usually the psychotropic drugs. I had a client when I was in Narrogin, her first ever, beautiful mum, worked at worked in the supermarket, really happy human being, and then unfortunately she did, just recreationally, smoked some dope, but it was laced with a particular particular drug called psychosis. She had a psychotic break, and usually it dissipates when the medication leaves the system. But unfortunately for her, it didn't. It changed her brain, and it left the door open for psychosis. So it became a permanent feature. And I was the one who had to deliver the news to her as well, because she'll stabilise, then we reduce the medication, and then the symptoms should have, she should have gone back to normal. And I was her worker. And when I saw her just before Christmas, I took her out for lunch, and I had to tell her that it's permanent, that she actually is schizophrenic now, and will be for the rest of her life. And we'll have to find ways to manage this condition. So they put her on medication, and she became almost catatonic. And it caused permanent damage that way as well. She ended up, so it was seen, and she ended up having this droop. So half her face looked like she had a stroke. She started to lose control of her face. She became disorientated, etc. And she was having blackouts and that sort of thing. And we quickly got her off it, but it was too late. Some of those features, those side effects, became permanent, those adverse side effects. And what I then looked at it further, I said, where are these drugs coming from, and who are they testing them on? Because they are really doing damage to a lot of to Aboriginal people, our patients. And they either come from Europe or they come from Asia. They're not tested on Aboriginal people at all. Not one bit. So these are quite dangerous medications, and they do cause exceptional harm. And we have documented research sensitivity to a whole range of mental health medications that doesn't still change the way they're dispensed to us. So we're vulnerable in that sense. And I know a lot of advocates have been trying to find other ways to actually try and change things, because we are making, there's a lot of vulnerability around that. And it's really concerning, because you can, like that, one of my patients, we can cause harm, permanent harm.
And are you aware of children in the child protection system being medicated to help with behavioural?
I've worked with children over in WA as well. I've worked with children here. I've worked as a youth counsellor at the first ever rehab, drug and alcohol rehab out at Hastings there. The profession mental health tends not to give a diagnosis to a child. Unfortunately, they do though give certain diagnoses, ADHD, defines certain disorders, and they medicate. We're throwing too much medication at everything. As you can tell, even though I love the profession, there are things about the profession I think need to dramatically change. But this is my opinion, by the way. It's shared by others, but I won't, if they can speak for themselves. And just medicating what can actually be, and more than likely is trauma. Human behaviour to trauma can come in all sorts of forms in response to trauma. And for men, a majority of men, and I know this because I've worked in all the spaces, including family violence, mental health, it can be violence, anger. For young people, for women, it can be also violence, but also shutting down, self-harm. A lot of young people self-harm. I mean, Western Australia has one of the highest is suicide rates in the world amongst Aboriginal children. And guess who's also, used to be young men, actually women are now starting to, statistically, their rates are going higher and higher. And it's trauma. So we medicate the crap out of kids, but we don't deal with the trauma. So that's what medication does. It just buffers, but it doesn't deal with the trauma. And I am a big fan of narrative therapies, things that are around nurturing and talking and healing through our old practices of yarning and sitting with each other and popping popping pills into kids' mouths.
I just want to take you now to some of your possibilities, the possibilities for reform that you've mentioned in your statement, and the one that comes up early is the use of Aboriginal healers.
I love that. Yeah, it's what I wanted here in Victoria. I wanted it actually across the country, and I've seen it in action as well, and it works. It's probably been around now, gosh, for about 6 years, 7 years. It's in Western Australia, Department of Health. They're registered under Medicare as well, so you can claim Medicare and seeing a mental health, an Aboriginal healer. And they're nominated, so it's a process where the community nominates their traditional healers. They are registered by the department and registered with Medicare, and they have their own number, etc. And the department, we ring them if they're requested, that they're on the list as part of the allied health team. And they come into the hospitals and they do herbs or whatever. They do whatever practices that are part of their cultural practices around a distressed patient who is distressed by a particular element. And I'll walk you through a particular patient. It wasn't my patient, but a patient that I've heard of. It was relayed to me by a colleague. Young fella had really stressed by the dingo that lived in his belly and was howling and howling and howling, Aboriginal fella out in the desert, howling and howling, and keeping him awake, distressing him. So he came in, and initially one would say that's psychosis. It has a feature of it, but it has a really strong cultural component to it as well. So they brought in his healer, and the healer, while not removing the dingo, calmed the dingo. And so the young fellow didn't hear the dingo anymore. If we had not had that sort of capacity to see it in a different framing, in a different framework, he would have been on psychotropic drugs and ended up with diabetes and probably dead by 40.
I want to also ask you about the recommendation that you've given for much greater focus on cultural plans, including the monitoring of cultural plans. Can you just speak about that?
Yeah, we know about the cultural that cultural plans are part of when a child is placed with a non-Aboriginal carer. The cultural plans have to be done. They're not monitored enough. Not all cultural plans are actually completed. Plus also the burden for them to be written and researched, etc., falls on the ACCOs, onto the worker. But yet they're not necessarily implemented or given oversight to be implemented. So all that work can on one hand can be really quite arduous to actually pull together, and it's burdened onto an already under-resourced, underpaid and overworked worker. and clearly click on the timelines as well, set not by the worker but by departments, because we haven't got the cultural plan. Sometimes they're just the last thing. So this is not everyone, but these are some of the faults that I've been told about. And they're not actually supervised as to how they've been implemented by the carer as well. So that needs to be reviewed as well. And you know, it's a whole bunch of things. Echo workers, they need to actually be better resourced, better paid. But also the department needs to actually prioritise the actual cultural plan, and actually needs to be collaborated between the two services as well, with the family at the centre. The actual family need to co-write the cultural plan.
You've made some comment about Aboriginal researchers and Aboriginal people being involved in the research and leading the research.
Yes.
And being involved in the development of the solutions and models that can be used. Is there anything more that you'd like to say on that point?
That's my big goal. I'm in research right now. I love research, and there's not enough. I mean, and when I say there's not enough, most research goes through universities. Doesn't have to be universities that do research. Communities can do their own research and should be doing our own research. I want to set up our own research institute down here, have our own research ourselves, and research issues that we prioritise, and it's actually stuff that's actually more localised, has solutions that are more localised, and that are actually coming from ourselves. So we can come up with our own models and our ways of doing things, and give evidence for that, to get funding for it, because there's power in that, and there's and it also promotes that self-determination as well, because there's problems, there's issues and problems, but guess who has the solutions? We do. So with Delta, I mean, they get funded around $100,000. Each region gets funded around $100,000 to disperse to the community, for the community to access for programs, specific programs. And you highlighted around family violence, one thing, or family or healing, maybe another area. But these are really small funding, short-term funding, to fill a little gap for a little while, instead of change things, change the entire generation. It looks good that you do that, because what it does is it just makes it look like we're doing something. But are we really doing something? I've told Delta they need to fund they need to fund Delta 5-6 times more than that per region, and have funding that lasts 3 years for a project, because you cannot map change. You have a project, you have a beginning, middle, and end, and you're trying to map its change. It's too short. We've really got to invest in spaces of community development and self-determination. Then we need to actually invest in it long term. Minimum 3 years. Minimum should be 3 years, not your maximum, but your minimum, up to 5 years. Even 10, I ask for 10 years funding if you really want to see some change. But that's where we need to think differently, because communities can do this. We just need the resources to do it, and the commitment from the government to let us do it our way.
Thank you. You've commented on a few other areas of possible reform in your statement, but one I want to draw your attention to is slightly removed from the child protection area, and it's...
Council, just 1 second, if you wouldn't mind.
Sorry.
Charmaine has been there for an hour and 40 minutes.
Yes.
Happy to continue, but I think she should be asked if she needs a break.
Just wondering about whether Charmaine needs a break at all.
Oh, no, I'm right, got my water.
Auntie Charmaine, I've got...
I'll be honest with you, I just want to get this over.
I've probably got five minutes left, if you're okay to hang on.
Absolutely, yep.
We have gone a bit over time, but...
Oh, have we?
Yeah, but...
I'm sorry.
No, not at all.
That's
not at
perfectly
all.
okay, and we're not impacting any other evidence, and your evidence is fantastic, so I'm happy to keep
But I
going
would like
if you
to have
are.
my closing remark in that photo, if you don't mind, so.
Okay. So what I wanted to give you the opportunity just to speak about, because it does cover, you do cover it in some detail in your outline of evidence, and I haven't asked you anything about it yet, and that is the nature of racial vilification and its impact on the community, and what you think needs to happen in relation to that area of the law.
Okay, I've just got to look back to which part of my testimony is it?
So you'll recall that you gave evidence to a parliamentary committee.
Yes, I did.
And that Hansard is attached to the statement, the transcript from that evidence,
Yep.
and you talk about your own experience. With pursuing a racial vilification case, and that's at sort of paragraphs 24 onwards.
Let me have a look. Oh, yep. Scrolling. Oh, yes.
Now, we've got the transcript from your parliamentary evidence annexed to your statement. We've also got the articles that you've written about racial vilification, and they will go into the evidence. And I just wanted to give you the chance to say anything else you wanted to say on that issue, or are you happy to rely upon the material that's already attached?
I'll just quickly say, yeah, that was in relation to that deliberate, in-your-face racism. The thing about the legislation is that it relied way too heavy. And when I read, I was like, you were joking me. Who wrote this piece of legislation? Sorry, government, if you're listening. In that you have to coerce. Someone has to be coerced into being racist towards you by a third party, not by your antagonist being racist directly to you. No, that's not the racial discrimination. It's when somebody outside of that person in your face joins in. That was the only, that's what it was about. I was like, what? So this other person in my face doesn't matter. That's not racial discrimination under the racial vilification. And it was true, yeah, it's about coercion. So when I saw that, I very readily agreed to give my opinion and response to that as part of the submission by Victorian Aboriginal Legal Service and Victorian Legal Service as well. But yeah, I mean, who hasn't, as an Aboriginal person, experienced racism? It's almost a pastime, which is what I said in my statements, my evidence to the inquiry. It's like an Australian pastime, racism. And it's not just in-your-face stuff or the online commentary, but it's also that subtle racism, which is something I raised in one of my articles. Media misses the point around racial vilification, because to most white Australians, racism is about the big blustery neo-Nazi types, that people that sort of those neo-Nazi white boys type things, yeah. when actually the racism is this small insidious stuff that can be in the room when an Aboriginal family is talking to a social worker. It's that's the biases that creeps around. It's paternalism. That's racist too. Paternalism is a racism. It's a form of racism. And it's like that, you're not like other Aborigines. That's also racism. It's that stuff that incrementally erodes and make sure that we stay in our place. Know that we're othered. And that's an inferior othering. And it can be, it's the backhanded compliments. It's that sort of sly, insidious that permeates. And a lot of Australians don't see that as, legislation itself did not see that as racism where it is. And it's that stuff that actually is quite, it's hard to grapple it. It's hard to put it down. But we know when you, your life has been an endless array of bigotry and crap. You know when you see it. I was walking home from groceries, supermarket from grocery, walking past, as soon as I turned the corner, young fellow in his 20s, well groomed, one of those hipster types, those with their beards and stuff. As soon as he laid eyes on me, bang, his face just went to total snarly, like he was about to throw up, just by the side of me. And I went, what the hell's going on? I didn't know how to react. But internally I just felt frightened and like, whoa. And he didn't say anything, but still his reaction to me told me this person's racist. This person doesn't like me and has never met me, but yeah. So it's that subtle stuff I want to really highlight as well, because it's not, the legislation should also be capturing how it makes the person feel than just the behaviours of the antagonist, but actually how it makes that person feel.
Thank you. Before we go to the final photo, I might just ensure that there are no questions that the commissioners have for you.
Questions?
I've just got the one for you, Anna Charmaine. It really triggered me when you were talking about these files, which are full of, or can be full of these racially framed biases and assumptions and opinions and pejorative interpretations. And this is just coming from the top of my head, but what if Aboriginal families had a right for an annual, supported by an ACO, review of what is written about them in files to be able to challenge those? Do you think that would make a difference about what was written in the first place?
Yes, and it also makes them think twice about how they frame things and be more reflective in their practice.
Thank you.
Thanks, Commissioner.
Auntie Charmaine, I'd just ask you to have a look at then the final photo that you've provided for us. If we could have that on the screen, please.
I just want to end with bringing it back to the personal and the journey.
So the other photo, please. It's next.
I can't see it.
There we go.
Can I see it as well?
You should be able to see it on your computer.
No, I can't. No.
It appears on your statement as Annexure 5.
There we go. Okay. So in closing, Commissioners, thank you for listening to me. But I'd like to reflect on the journey it takes Aboriginal children in care who are severed from their families, communities and identity to fulfil their own life's aspirations to its fullest. What we do to a child will affect not just their trajectory in life, but their entire sense of self-worth and identity. My journey is such a case, as depicted. I had many challenges, some which were not of my control, and many which had the most profound effect, not just on myself, but my brothers and sisters and my parents, Eliza Elizabeth Saunders and Lawrence James Clark, who without them I would not be here today. You saw earlier an image taken of me when I was a child with my siblings and a ward of the state in lovely clothes in front of a lovely building, but still a ward of the state. But there is this image, taken now, it's taken this year, at the age of 55. It forms part of an exhibition around the stolen generation by artist David Jones. When David sent me this image via email, and I saw it for the first time, I wrote back to him, "David, these are extraordinary. You have given me permission to actually see myself, not how society bends me, constructs me for either ridicule or pleasantries, but actually see me, myself, in such a poignant and autonomous way, this bringing tears, and still does. What a gift, a most precious gift as well. So many First Nations people are so tempered by the relentless negative discourse that permeates all aspects of our society, generation after generation, to the point we are vigilant, which is a defiance and not palatable, or we retire bruised, worn out and submissive to the point that we fold inside ourselves. I've lost my voice, my fire, my inbuilt trust to believe in myself to a profound degree, especially after I lost my dearest sister at the age of 33. But these photographs tell me many things, and among them, from my immediate response, is that we have beauty. We have stoicism. We have a real and deliberate presence and purpose. Thank you.
Thank you, Charmaine. If I may, I'd just like to thank you so much for the honesty, the compelling way that you've presented today at a distance. It has all come through the screen, and we're very, very grateful for your honesty, the strength of your voice, and it is on the public record for all to know about.
Thank you, Commissioner, and thank you, Commissioners.
Thank you.
Thank you.
Thank you.
Now, Commissioners, it's proposed that we take a break before the next witnesses at 1 p.m. And so we can adjourn at this point.
Thank you. So until
Oh, sorry, one thing before we adjourn, I should tender the outline of evidence of Auntie Charmaine Clark dated 7 December 2022, together with the annexures thereto.
Thank you. Make those orders in terms sought. Thank you, Council. We're adjourned until 1
p.m.
Thank you.
Thank you.
Council.
If the Commission pleases, I'll announce my appearance. Sorella Fitzgerald, Council Assisting, and I understand that States Council has not yet announced her appearance.
Good afternoon, Chair and Commissioners. Ms Caffarella for the State.
Welcome.
Before I call our next witnesses, we seek some orders that we wish to make under Section 26 of the Inquiries Act for sensitive evidence. Namely, that any identifying personal details deemed sensitive in the letter from Corinda Taylor to the Department of Families, Fairness and Housing, dated the 30th of August 2021, tendered as an attachment to the witness outline of Corinda Taylor, not be published by Yoorrook.
We'll need to talk about the form of that, because it's not possible to identify what the not to be published material is. You've relied on the idea of something being deemed sensitive. Is that obvious? I want to be sure that the order achieves its purpose.
Yes, Your Honour. I think the intention is that it is the identifying personal details, and there was just a lack of clarity in the way I described it. It is any identifying personal details.
Yes.
Comma, deemed sensitive.
Thank you.
Sorry, Your Honour, that was a bit of laziness, but it is just the personal details.
Yes, thank you. That's clear.
And the case studies and quotes from frontline practitioners set out at pages 24 to 39 of the submission from the Safe Start Coalition, dated the 5th of December 2022, and that is that is on pages 29 to 39, but it's also, Dr Cracker has also provided a redacted version, so it is very clear that it is just the case studies on those pages. And the third item is the doctoral thesis of Dr Cracker, entitled Journeys of Connecting Understanding Cultural Connection for Journeys of Connecting Understanding Cultural Connection for First Nations Children and Young People in Out-of-Home Care in Victoria, Australia, dated April 2022. And that is Dr Cracker's PhD, which remains embargoed. And then any oral evidence in respect of those matters, to the extent captured in a transcript or video recording, not be published. And that last order relates to a very small amount of evidence that I will address separately at the end of all of my other questions, so that that we're not opening and closing a number of times. So at the very end, I will ask that the live stream be ceased in order to accommodate that evidence.
Okay, thank you. So I make those orders in the terms sought. Thank you, Councillor.
Thank you, Chair. We'll start with Dr Cracker in terms of administering the undertaking. Dr Cracker, do you undertake to provide truthful evidence to the Yoorrook Justice Commission today?
I, Jacinta Cracker, solemnly and sincerely declare and affirm that the evidence I shall give will be the truth, the whole truth, and nothing but the truth.
Dr Cracker, you made a written submission to the Commission dated the 5th of December 2022, along with other members of the Safe Start Coalition, and have provided other academic materials in support of that submission, which you request the Commission to consider. Is that right?
Yes, that's correct.
Doctor, will you introduce yourself personally and step through your professional history and academic qualifications?
So my name is Dr Jacinta Cracker. I'm a Minang Noongar woman, originally from southern Western Australia with family ties to Noongar country. I have grown up and lived in Naarm my whole life. My father is Phil Cracker, and we moved to Melbourne when he played football back in the 1980s, and I remained here in Naarm for my adult years and throughout my childhood. I have a professional background as a social worker, and I previously worked in the out-of-home care system, first as a child and family welfare worker in the family support and early intervention team at VACA, then in the extended care team as a foster care caseworker at VACA. I later re-entered the system and worked as a residential carer for On Call. I have a social policy master's degree from the University of Melbourne in addition to my social work master's degree from the University of Melbourne. I then pursued a research career and undertook a Doctor of Philosophy from the Department of Social Work at the University of Melbourne, and it is around the topic of cultural connection for Aboriginal and Torres Strait Islander children in out-of-home care in Victoria.
Thank you, Doctor. Now, Ms Taylor. Corinda Taylor, do you undertake to provide truthful evidence to the Yoorrook Justice Commission today?
I do. I, Corinda Taylor, agree to provide truthful evidence to the Yoorrook Justice Commission today.
Ms Taylor, you've prepared an outline of the evidence that you seek to give the Commission. Are the contents of that outline true and correct?
Yes.
Now, Ms Taylor, if you could tell us about, firstly introduce yourself personally and professionally, and in doing so, tell us about the work that is done at First Peoples Health and Wellbeing.
Yep. I'm Corinda Taylor. I'm a Wamba woman, born and raised on country, northwest Victoria. I've lived in Naarm for approximately 10 years now, raising my family, my husband. Don't raise my husband, but I have got a nursing and midwifery background. I've worked in the profession across both hospitals, acute and metropolitan hospitals, as well as out in the community in Aboriginal community-controlled health organisations, which has led me to be the CEO of First Peoples Health and Wellbeing, an Aboriginal community-controlled health organisation with clinics in Thomastown in the northern suburbs and also in Frankston in the southeast. The organisation effectively provides culturally safe, trauma-informed, wrap-around preventative primary health, social emotional wellbeing care to local Aboriginal communities.
Thank you, Ms Taylor. The first issue that I wanted to ask each of you is about the issue of racial bias, racism in the child protection system. Ms Taylor, in your outline of evidence you say that the child protection system operates under the assumption that Aboriginal people are bad parents and then interprets all their behaviour through that lens. What has led you to that conclusion?
I've got over 15 years' experience as a nurse and, more importantly, as a midwife, which has brought me into contact with child protection. I've never deliberately worked within the child protection system from a social lens, but certainly from a broader health and wellbeing lens, and then managing First Peoples Health and Wellbeing as the CEO has me dealing with child protection pretty much every single day. And some of the cases that I wish to talk about today are not just from over the last 15 years, but as recently as yesterday. So, you know, it's a huge question. I think we find ourselves having endless, exhausting conversations with child protection, both on the ground individually with some of the practitioners that are assigned to some of the Aboriginal children's cases or files, but also at the highest level in the region with the regional director around some of the, you know, concerns that we have around the system and wanting to address those. Effectively, what we find is that we get this misconception about what good parenting looks like, and I know Dr. Cracker will like to speak about that further as well. But we find that while the cases are somewhat different, and there is many of them to discuss, I think, you know, there's these common themes that talk about this expected standard about what good parenting looks like, and, you know, we know that that's, you know, doesn't necessarily meet the standards of the practitioners that are dealing with the cases.
And how does this, the expectation that child protection practitioners have about what good parenting looks like, disadvantage your clients?
I think one of the things is that there's an expectation that the unrealistic expectations that are placed on families to meet. So sometimes it's the criteria to either keep a child in their care or whether it's to get their child returned home. There's an assumption that people have got the means and resources to meet all of those things. And one of the examples is, you know, sort of setting up a young family to live in, you know, the outer sort of west of Melbourne and then expect them to come back over to our clinic, once, 2, 3 times a week to, and so there's these sort of hurdles that are unrealistic. They cause further financial disadvantage.
If I can add to that, I think it's a really loaded question, right? Why is there racial bias within the child protection system in Victoria? And to unpack that and understand it, we firstly need to contextualise it within the history. So we know historically that Aboriginal parents had their families taken away from them because it was deemed that these children were not being given the standards that they should. They should, in inverted commas, based on the nuclear Western concept of what a good family looks like. So we had Aboriginal children taken away from families because of circumstances like poverty. We had them taken away from our families because culturally we were rearing our children differently. And the reality is we are a different culture, okay? So all cultures raise their children differently in accordance to their cultural values and what they think children should have rights to, how they think children should be raised. Historically, children have been raised within European cultures very differently. So children have been raised to to sit and to not speak in the presence of adults. For example, if you look at Victorian era understandings of, child rearing, children should be seen and not heard. We've evolved now. So historically, we saw children in one light. Now we see children differently. We want to see them as agents who are self-determining and have their own voice and their own power and their own control. Aboriginal people also have a very complex and beautiful history, a very, very strong cultural, kinship, grounded, connected history of rearing our children in line with collective styles of child rearing, which don't fit with the Western understanding of the nuclear family. Now, that Western understanding of the nuclear family has been imposed on our families historically, and it continues to be structurally imposed by the Children, Youth and Families Act, by the child protection system as a whole, because the principle underpinning that act is the best interest of the child. That's understood through a very Eurocentric way of disconnecting that child from their family, from their community and from their cultures. It sees the child as an individual, a child that is not connected. We see ourselves as interconnected. We have relationality as a beautiful, complex, interwoven system where our children are not just an individual. They are child as future. They are child as community. They are child as belonging to a family, as belonging to a country, as belonging to a community. So when you separate that child, what you do is you actually disconnect all of those beautiful strengths and protective factors. You disconnect them from the whole. And the system actually struggles to see how our cultures differ, and it operates on this kind of invisible assumption that families should rear their children like a white middle-class family. And I say a white middle-class family because historically, child protection in Victoria has actually targeted people on the grounds of class. It's targeted people on the grounds of disability as well as race. We know that. So it's not that the individual practitioner is necessarily racist or is saying, I think that this child should not be raised in this way because I just don't like Aboriginal people. This is actually a structural issue. It's a structural problem. And that's what we're trying to get to. The complexity of child protection systems is that behind every decision, behind every intervention into the private realm of family life is a normative assumption about what constitutes good parenting. And that is subjective. That is a fact.
Dr. Cracker, you've spoken about this broader concept of Aboriginal conceptions of the child as being very much a part of their community and defined by their community. Can you provide some more practical examples at perhaps a more granular level of how the child protection's construction of good parenting as middle-class white parenting conflicts with an Aboriginal view of good parenting?
Absolutely, I can. I can think of examples where, from my case history, where Aboriginal children have been placed with the non-Indigenous side of the family because the non-Indigenous side of the family is seen to be providing them with a house that looks more like a standard of good parenting. So the non-Indigenous side of the family might, for example, own their own home, have a spare bedroom with a bed for the child. They might have, you know, the latest fridges and technology, right? They might have like all of these financial resources at their disposal. The Aboriginal side of the family might have mattresses on the floor because they can't afford to have each child have their own bed. So they're living in circumstances of material poverty. So they've got the mattresses on the floor and the kids are sharing the lounge room, and that's where they're sleeping. Or the door's been kicked in the toilet, and they can't afford to replace it. So when someone wants to go to the bathroom, they chuck up a mattress and they cover that door up. But for Aboriginal families, and I'm thinking like my own family, right? That's normal for us. Like we are used to living in circumstances of poverty because colonisation has created that poverty, that intergenerational poverty and that trauma, that even though we've got access to jobs now and we can go out and we can buy our own houses and we can buy our own cars, there actually are some families out there, and this is the reality of the child protection system, these families are doing it real tough. They are out there and they are struggling. And when they ask the system for help, what happens is they are met with punishment. They're not met with help. They're not wrapped around, therapeutically supported. We don't work with the whole family in a trauma-informed way, a way that's culturally safe, a way that says, hey, what do you need to be able to look after this child? What support do you need? What can we put in place? There are no poverty alleviation measures. Child removal happens because of issues like poverty.
But Dr. Cracker, do you agree that a child should be removed from their family if they don't have the financial resources to raise them?
It's a loaded question. My personal belief, and it's founded on a research evidence base, is that it is one matter to deliberately withhold food and shelter from a child. It is another matter when you simply cannot afford to do so. I personally believe that the state has a responsibility to look after these families, given that the state has, through history, perpetuated the damage and put Aboriginal families into positions of poverty through colonisation and hasn't resourced enough of the therapeutic holistic supports to enable families to get themselves out of the situations that they are in. So that's why I believe that the state has a responsibility to Aboriginal people in Victoria, because it has ultimately created the issues. And to fix the issues, we must respond to the scale and extent of the problem. So I don't think that we should automatically resort to removing a child because they financially cannot provide for that child. We should be doing things like raising the allowance of New Start payments, putting in place child poverty alleviation measures. We should actually be trying to support and help, because Aboriginal families have shown that, you know what, some of us have always lived in poverty. My dad grew up on a reserve in Mount Barker. He grew up in poverty, and he will tell me that those were the best years of his life because he was surrounded by his family and his community, and he was provided with love. The power of love is something that a system cannot provide, but our families can.
One of the things that you mention in your submission is this idea that child protection systems should not be removing children from poverty, but in fact assisting them to flourish in poverty, that the idea that poverty in itself is not inherently detrimental to a child. And how do you see the child protection system currently responding to poverty?
I think it responds to poverty through firstly referring children out and families out to child and family support services, relying on the support services to provide for the family. So as an example with housing, putting people on a public housing wait list, that could take 2 to 10 years to be able to secure a house. It then relies on the resources that are available within that organisation. And the reality is that these families are living in circumstances that are deemed risky by the child protection system, and they're struggling and they need help and support. And when they're on wait lists, when they're getting piecemeal support from Child and Family Welfare Services, because they are also bound to the resources they are allocated, and they have checks and balances in terms of how much support, material support they can provide, the effect is that the risk compounds, it heightens and becomes more and more dire, to the point that child protection then feels it's necessary to respond with removal. But those options prior to removal haven't been adequately explored.
Ms Taylor, I wanted to speak a little bit more about the idea, the assumptions that you see the child protection making towards some of your clients. You've said in your witness statement that child protection takes a judgmental and patronising approach to Aboriginal mothers, which is mostly who you're working with, which you say takes their voices away. What does that look like in practice for you?
I think a range of things. One of them is being able to articulate, the ability to look after a child. And I think when we talk about protective factors, of course we need the resources to be able to support a child. What we find is when a child or when a family is looking for some of those support services, the organisations are under-resourced. They struggle in a supportive way, both from a health perspective, but also a broader social and cultural determinant of health support network. There's actually very limited resources. So the supports actually aren't there. And it's no different to mental health and AOD. We wait till people are in crisis. That's where all the back-end tertiary dollars sit. So when I think about child protection, we see families reaching out to organisations, both Aboriginal and non-Aboriginal organisations or mainstream organisations, and the supports just aren't there. People fall through the gaps all the time. So even articulating what's required to support. Some of the more tangible things that seem really obvious around transport or food security, clothing, schooling, education, health literacy. Like there's a range of things. In my experience, child protection workers will often ask questions that, they're fully loaded. They seem to trip up our families. They go to articulate what they're, I see them having a conversation with me, and then a child protection worker walks in and they all of a sudden start stuttering. They're just so frightened of saying the wrong thing that actually they end up saying the wrong thing in the eyes of the system. I think there is a lot of goodwill with the majority of child protection workers. I've worked with some great people within the broader system, and that's, while the systemic sort of racism broadly, and it's a huge can of worms to open. But on an individual level, I have seen these sort of expectations talking with a level of authority that's, almost sort of dictatorship around, we're not going to meet in the middle and find an even keel here. We're going to tell you what you're going to do, and you're going to jump through all these hoops, and you'll do it in an unrealistic time frame that sets up the families to fail. And then if you add the complexity of something like a disability, which is one of the cases that we've put forward, in the witness statement and in some of the articles, I can just see that we should be scaffolding around our families that have got a range of other complex issues, whatever they are. And what we find is the more complex the family dynamics are, for whatever reason, the less help there is. And so what frustratingly we see is that people ask for help, and then once they get into the tertiary end of the child protection system, all the resources in the world are provided to often a non-Aboriginal carer. And it's actually really frustrating because I've had all those supports being given to the family in the first place, and that's sort of what Jacinta was sort of alluding to, is that we probably could have kept them together in the first place and done not quite so much harm.
Ms Taylor, how could it be, so I'll just clarify that question, then how could it be that the more complex a family's problems are, the less supports there are? How could that be?
I think the education in terms of, awareness, understanding bias, lack of understanding of, disability in this particular circumstance, but even mental health, drug and alcohol, a range of things. And I don't want to be really negative. But I think the complexity of some of the families, often we silo funding and programs down onto the ground. And, it's not self-determination. We've been screaming out for a long time about what holistic health looks like. And we are somewhat trying to wrap services around, and I'm talking about us as an organisation at First Peoples Health and Wellbeing, but broadly, Aboriginal community controlled health organisations and other support services will look at wraparound services. The reality is we're trying to manoeuvre this siloed funding, reporting burden and all of those things that we could get into. And the reality is that mainstream don't do complex care very well at all, actually. And often, there's sort of a remit of what the funding will be used for. And you see organisations like ours constantly stretching them to ensure that we navigate in the background what those complexities are to support a family. But with limited resources, it's actually really difficult. So we rely on the partnerships with other organisations, including Mainstream or social care services that actually know very little about health and broader wellbeing in terms of holistic health. And so we try to put some sort of padding and buffer in to support families to navigate a system. And the complexity means that they're trying to navigate sometimes 30 different programs. It's really hard.
Dr. Cracker, there was something you wanted to...
Yeah, I was just going to add to what Corinda was saying is there are multiple service systems that come into contact with the child protection system. So I think what we need to understand is that there isn't just an issue with child protection and the child protection system. There is issues with families with needing support from multiple different services. So you might need disability support, you might need support with family violence, you might need support with alcohol and other drugs or mental health. And you're going to different service systems for each one of those, and those services don't work very well together. The Royal Commission into Family Violence found that. There's actually not a very good level of communication and cooperation and transparency and connection between multiple different service systems. And that's part of the complexity of child protection systems. Multiple different mandated reporters come into contact with the child protection system. The police are statistically the highest group that make notifications to the child protection system. Nurses are up there as well as teachers. Health professionals in general. So we have all of these people in society that have their own normative assumptions about good parenting, might see a child in a particular circumstance and might make a notification because they're concerned, legitimately concerned, but they don't necessarily understand how the system functions and the complexity behind those decision-making processes within the tertiary child protection system. They might not know of the available supports and how we could actually work holistically and wrap around support so that you're getting support within one place, like a one-stop shop, but for multiple different things. And I think that's part of the challenge of child protection. But the irony is that families might be struggling and they might not have enough material resources and the state might remove their child from them. But when our children end up in the out-of-home care system, the state acts as a negligent parent in some cases. And I can give you an example of that. An Aboriginal kinship carer had a 3-month-old baby dropped on her doorstep at 10 o'clock at night with $20, a bag of clothes and enough formula for 2 bottles. She had 3 other kids in the house. This is a registered kinship carer, an Aboriginal woman who's actually doing it tough, has these other children, one of it which is actually in state care, so in the out-of-home care system, and then the state does that. Now,
And,
that's a double standard, isn't it? If the state were to act in a way that, if the state were upheld to the same standards that our families are held to, the state would have the children removed from their care.
And Doctor, this idea that Ms Taylor was mentioning, which is that almost the more complex things become, sometimes it gets trickier to get any funding for it. Is that also because sometimes there are exclusionary criteria on certain bits of funding, so that if you have a second problem, that excludes you from funds for your first problem?
I'll defer to Corinda on that one because she's more familiar with the funding arrangements.
Is that an issue, Ms Taylor?
Yeah, and in my witness statement, I talk about a case where we had this exact circumstance. So we had, we've got a woman who's 27 biologically, but due to her disability is much younger and needing, supports. And there is some systems where youth programs would accommodate someone like this mum. The thing was that when we went around to literally around about 30 different programs to get her support to try and keep her and her baby, newborn baby, as a unit together while she worked through whatever the risk factors are that, the department wanted to, for her to sort of tick off before they could sort of leave her alone. And the reality was that everyone you rang, most of them were like, well, we're only youth, so we can't look after her. We're adults, but we can't support her disability. We can't take a baby. We can take a baby, but the Child Protection have got 24-hour surveillance support across her, and we can't accommodate absolute 24/7 support, and so she can't come here because our resources won't allow it. Now, that one alone was the real sticking point across a range of these services. Now, this woman had her own little 2-bedroom apartment. She was, just so happy to be able to provide this home for her child. And very little was done through her pregnancy, which was a beautiful window to address whatever the concerns were. So while they physically could not remove the baby, let's address them. When
you say that, is that what did happen, or that's...
This is so during the pregnancy, there was very little involvement with Child Protection. Yes, there was the unborn notification. We were aware at our organisation that the baby had an unborn notification, so we absolutely, and this is rare, we rarely know about them. In this circumstance we did because mum was really engaged, and she went for an assessment through a mainstream early parenting centre that did not work for her. So there was a range and this cascading level of intervention that anyone would sort of crumble under. She didn't last probably 48 hours or so. And in the end, she came to my home. And so my midwifery background, the agreement with Child Protection to keep them together. And it was extreme. I've done it once and I'm not sure that how many times I would do it. But it was really important that we demonstrated that the same assessment template used within this early parenting centre could be used with a different lens. So my lens.
You took the assessment?
I took mum and a newborn baby and their assessment tool and did a 10-day assessment in my home. I gave her the breathing space that she needed to actually be able to relax. And if she wanted to sing to her baby, I didn't go, oh, it's a funny song to sing, and that was the level of, and I know that sounds really silly, but this was the level of stuff that was written up. So I remember looking at her, talking to her baby, those cues, attachment, bonding. She was so attentive, and I wrote attentive. They wrote intense. She was intense. They actually sent it as a really negative. Had she ignored her baby, they would have wrote that up as well. She used common language like titty for breastfeeding. They wrote her up for using sexual language towards her child.
Is your understanding that was the word they viewed as sexual language?
Yes. Yep. The word titty was seen as using sexual language, inappropriate sexual language towards her child. Now, this was this particular case. This woman has her own. She'd been in the child protection system herself, and within that system, under the state's authority, was sexually abused repeatedly over many, many years. So to then be written up in this report that she was aware of, that she'd used sexual language towards her child. Parallel to that, with another health practitioner, she was breastfeeding the baby, told to breastfeed on demand. Now, this is a woman with an intellectual disability. She takes you quite literally. She was told that, if the baby's crying, like, is it wet? Is it dry? Is it hot? Is it cold? Is it hungry? Just keep going around that cycle. And so she's breastfeeding, you let demand feeding, you let the baby feed. And I know I'm giving you lots of information, but this was sort of, what was sort of discussed with her. She was really clear about, these sort of caring factors for her child. And she was breastfeeding. Someone came in and said, "Oh, you're still breastfeeding. Who's enjoying it more, you or the baby?" And this is just the most appalling. This was the final point where she said, "I cannot stay here." So she has gone through, these sort of, and this is what the original question was around, this sort of racist, negative, talking down to her with a level of disrespect that no one else would just put up with. And she did that because she was fearful that if she stood up for herself or said, "I don't appreciate how you're speaking to me," that's a black mark and we're going to take your baby away. She was always waiting, and they treated her with a disregard that said, "We know you're going to slip up. We haven't quite got the documentation right now, but we'll get it eventually." And had she stayed there for a minute longer, they would have had it. And had the opportunity not come for me to go, "How about I take her and I'll do the assessment?" And we provided her a safe space. She could look after her child. Of course, I supported her. We did dinner together and had family meals, and she really enjoyed it. She had an NDIS package that was grossly underestimated for what she required. And in that 10 days, coincidentally, we went and got her NDIS package reviewed. And her package went from about, I can't remember what it was, but it was minimal, like 10 grand or something. And it ended up about 100,000 over the next 6-month period. Intense supports, 7 hours a day. It was a lot. But if it meant child protection got off her back, she was happy to do that. Again, she had her own unit. She paid her rent. She had her little place that she'd got ready. And when I went to her home, she was proud as punch of this little place. And her baby by then is about 3 weeks old. She's been into court a number of times. And to actually finally go home and just relax, I barely slept that night thinking, how's she going at home on her first night with her baby? Went back the next day and she just looked refreshed and well rested. Child protection didn't get off her back, but they did get to stay together. And the court thanked me for providing a culturally safe, supportive, strength-based lens to this report, that wrote a report that was so different to the previous report that it was just this evidence that said we need to do things differently.
How many mothers do you think could do with that ad hoc service that you provided, and how many times have you been able to provide that service?
Yeah. I've done it once, and, I have a family and I, want to keep my marriage, so I don't know how many times I would bring people into my home. Having said that, we have written a significant report with Dr. Cracker and some of her colleagues from Monash University around the need for culturally safe Aboriginal-led early parenting centres. And the report overwhelmingly says it needs to have a health lens because, and I don't think about health in a biomedical model, and I think that's the misconception, that we're not looking for health, we're looking for the broader social, social and cultural determinants of health to wrap around. But from an Aboriginal lens, that's what a health and wellbeing response would look like. It's about going back to the preventative, taking that window of the pregnancy and saying, what a beautiful time in a woman's life. It's transformational. You see women when they are pregnant, we all go, oh, we're going to walk more when we get the pram, and we're going to breastfeed, and we're going to eat healthy. And, it is a time in a woman's life where they say, I want to be the best mum ever. Do they have absolutely all the means? Maybe not. Should they then, not be counted as a good parent or the intent to be a good parent? Should they not be provided the opportunity and get the support services? Of course they should. And Aboriginal-led early parenting centres, and we at First Peoples Health and Wellbeing have very proudly accepted an opportunity to establish the first Aboriginal-led early parenting centre in Frankston. And it wasn't by whim, by the Andrews government to, sort of pluck out an area. The report that's led by Dr. Cracker outlines this overwhelming need. And we know that there's a national crisis around child protection, and furthermore here in Victoria. And then if we want to pinpoint more, we go down to the Bayside Peninsula, where 1 in 3 kids in our clinics at the moment are in some sort of child protection involvement. It's dire, and it's every single day, and it's relentless.
Can I just say too, kudos to the Andrews government for making this investment, because the report did a needs analysis where we looked at population growth and the need based on the existing service levels and demand. I did a systematic literature review to actually see what the evidence was saying about what an Aboriginal-led early parenting centre could look like, and how could we actually do things differently. How could we actually do it with a health perspective, so in the broader sense of the word of what health means, social and emotional and cultural well-being. And the Andrews government stepped up and they made that commitment. And with the election win, that is something that will be funded. And I think this is part of the challenge with the Victorian child protection and out-of-home care systems, is actually within the Victorian government right now, there is a lot of goodwill. I personally know a lot of great workers within the child protection and out-of-home care systems, and I work alongside them as a researcher. I know people through practice connections and links with people on the ground. And they have made this commitment to self-determination, and it is a wonderful commitment. It is the right principle to enforce, I believe. And I think the evidence does show that self-determination can be transformative for Indigenous peoples. That's why it's enshrined in the United Nations Declaration on the Rights of the Child. It's why it's been pushed and advocated for within Victoria's out-of-home care system. The problem is that there actually is a disconnect between the policy and the practice on the ground. So we're struggling with self-determination because within the Children, Youth and Families Act of 2005, what it states is that under Section 18, a child can, the statutory powers of the Secretary can be delegated to an authorised officer, I believe, of an Aboriginal agency. What that means in practice is that the CEO of an Aboriginal org, so an ACO, such as VACA, will have the delegated authority to look after that child when they are under a protective order, which may place them into out-of-home care. It may be a family preservation order. They might have those powers there. And then they can delegate those functions and those powers down to their employees within that organisation. But we need to be thinking self-determination, right? It's about power, control, agency and freedom to pursue your own interests, the freedom from government interference. So it's about control and agency, but it operates at the individual and the collective level. When we transfer power to an organisation, we're thinking about collective self-determination. We're not giving the individual that power of self-determination. We're not saying to the child or the family, which service do you want to go to and get support when that child has gone into out-of-home care or is within the child protection system. We're not saying, who do you want to work with? We're not asking, well, who are those workers within that organisation and how supported do they feel, or what cultural mentoring and supervision are they getting? So it brings up this whole host of other questions, right? And this is part of child protection and out-of-home care, is they're so complex. They're so complex. But I've seen cases from my time working in the field where you'll have workers go out where families are doing their absolute best to keep their babies. Pregnancy research has shown it's this transformational period where people just want to be able to look after their kid, and they will go above and beyond to look after their babies. And they are doing absolutely everything they can. One young Aboriginal girl I worked with, she had an intellectual disability. She had had a previous child removed, which is actually used as a risk factor to intervene into a subsequent child. She had a history of prostitution, so had been a sex worker, and that was constructed as a risk. She had substance use problems, and she was currently on the methadone program. So she had multiple risk factors sort of interplaying in her life. Because she had an intellectual disability, she had her payments actually quarantined, and she would get an allocation. So her payments from the disability payments, she would then get an allowance to spend on her baby, to spend on food. And there were times where she put her baby's needs well and truly above her own. I would go out there and she'd have nappies and toys for the baby if she could afford them. She would have food, everything for that baby. And I'd say, when was the last time you've eaten? Oh, 3 days ago or so. And I'd have to argue to spend brokerage within the organisation to buy this woman a feed. To the point where I'd just use my own money in the end and I'd buy her food, because how can someone live without food? And yet the system, and I remember this caseworker saying, can you believe she didn't even have a monitor? She didn't even have a monitor. How can she know if that baby's sleeping right when she hasn't got a monitor? Now that's an example, right, of this middle class standard. You don't need a monitor to see how a baby's sleeping overnight. It's a privilege. It would be nice. It's not a necessity. I remember this caseworker, and it was a white woman who had actually come from the department, but was currently working at the same organisation as me. And she said, I can't believe she had so many toys in that cot. That's a hazard. That's a smothering risk. I see that in a strengths way. That's a mother showing love to her child. That's a mother wanting her child to have the best. That's a mother with an intellectual disability who's trying to learn how to parent, because parenting doesn't come with a manual. But it's seen within the system as a risk, and it's a function of the system, because the system is highly regulated, which makes it bureaucratic, which makes it authoritarian, which makes it so that if a caseworker, an individual caseworker, misses a potential risk and something bad happens, a baby dies in state care, that caseworker is going to be held to account. So that caseworker doesn't want to stuff up. That caseworker has to have checks and balances. There must be multiple levels. So it's really a systemic issue that is very complex.
To what extent do you see this, I suppose within the child protection system, but also, in the general media and society, this blame culture, so that, as you say, there are headlines, very vitriolic headlines, vitriolic towards child protection, if something goes wrong. To what extent is that creating an unhelpful culture and a risk-averse culture within the child protection system?
I think it's massively creating a risk-averse and unhelpful blame culture within the child protection system. It's not helpful at all. What we see whenever there typically are sentinel events, so responses to a child death, there is this automatic sort of emotive reaction to go and find what went wrong in that case. Who is at fault? Who can we blame? And there is often this knee-jerk response that's put in place to try to ameliorate and fix these issues quickly. The thing with child protection is, because it's based on a subjective interpretation of what constitutes child maltreatment, there are no simple answers. There are complex answers. And governments struggle to sit with complexity and deal with complexity. They struggle to implement complexity in policy, and when it doesn't quite work out on the ground, sometimes we have the reaction where we remove the policy because we think that the policy is failing. The policy may not necessarily be failing, it's just that on the ground we need to tinker and we need to get things right, because we can't predict the outcome. We don't necessarily know what's going to happen. I think if you look around the world, we see different models of child and family welfare systems and different models of child protection systems. It doesn't have to look the way that it currently looks. Scandinavia is an excellent example. They have more support structures put in place within their systems. They are focused more so on the side of providing support. If you look to Aotearoa, New Zealand, the response with Māori communities is actually moving towards more of an orientation around the community as opposed to the individual. Whereas Victoria, we have a very individualistic orientation. It is bureaucratic and it is highly regulated. If we look at some of the research evidence base around typologies of child and family welfare systems, they don't all have to look like that. That's one model. There's other ways that we can do it. And the blame game is not helpful because the reality is that, and this is the need-bias debate, there are some families out there that are doing it tough and do have great need for support with family violence, for support with mental health, for support with housing, for support with substance use. And some of those factors do present a genuine risk to the safety of the child. Okay, so that is true. That is something that is a reality of the system. On the other side, some families also need the support, and there is also a bias around that support that is given to Aboriginal families. There is actually bias infiltrated into the tools that are used for decision making. The bias that is put behind the risk notifications and the way in which we concentrate on risk to the neglect of the strengths. There is bias inbuilt in that. So both factors are actually at play here. We have disproportionate need, yes, because of our history, because of colonisation. There is also structural bias embedded within the system, a function of the system historically, culturally. It reflects the culture, where we are at in Australia. And that's something that we need to grapple with. Blame game culture, it's not helpful. It's not helpful to it at all. But what we can do is imagine ways that we can do it differently. Right? We can get excited about the possibilities.
And I'm looking forward to hearing about that. And we will touch upon that shortly. One of the things that you did mention, I was going to ask Ms Taylor about, it comes up in your outline of evidence, is the fact that child protection fails to recognise the support systems that Aboriginal parents already have in place or could put in place to keep their family together. What sort of support systems are you talking about?
I think one of the things that child protection neglects to find important is that putting in preventative support measures at the front end, so, further that people go down the child protection system, the more harm we do, and then we try to undo that. And most of the work that we do in terms of the social emotional wellbeing is about trying to heal some of the hurt that's been created, not 10 years ago or 3 generations ago, but today. I think communication is just so poor. So there's this misconception that the health professionals in an ACCHO, for instance, got their degree potentially at the same place that those that are working, so in midwifery, those that are working in the birthing hospitals. And I went from working in a birthing hospital to working in the community in an ACCHO. And it felt like overnight that my credibility as a health professional just dropped off purely because I was working in an Aboriginal organisation. I must have a Mickey Mouse qualification and no experience. So the complete disregard of what the strengths and qualifications and experience and cultural knowledge that the broader workforce brings within an ACCHO is not considered as part of the help, part of the broader system help. So we're some people that will reach out so much that they almost burden our system because we're not resourced appropriately. Or you get the flip side, which is the majority, that actually do not even start conversations at all. So, of course, in the unborn space, we are not aware that cases, unless a mum is aware of a case, we will, find out after a baby's born that the first person on that woman's doorstep is a child protection worker before any of her family, which is just soul destroying to hear, and it's repeated. And then, the thing about the risk and the blame is that this sort of blame culture is also just shifting the buck. So in terms of accountability at the absolute highest levels, And what happens when there is an event where, you know, something adverse happens, and often very tragic, is that, of course, the community from the ground up says this cannot happen. At the same time, make it a white baby, and the magnitude of that voice is so much stronger. But we get, you know, where that accountability should sit, whatever that looks like. And I don't want to look like I'm doing the blame or the finger pointing, but the reality is that the system is broken. We know that. I'm sure you've heard it repeatedly, and from some of the live streams that we've heard, people keep talking about this broken system, and what does that mean? The reality is at every single level, both at an individual, you talk to individuals, they say, I am so overrun. I have such a full case. You know, yesterday I spoke to one of my GPs about a mum who was absolutely distraught, and her entire consultation was about the fact that it's her son's birthday today, and she's been asking for weeks and weeks and weeks to see her son on his birthday today, and yesterday found out that it was a flat no, and the excuse was, I've got a full diary, you and your son are not the only people on my books, and I just cannot change my diary to accommodate you. I mean, that's the reality of what people are doing. There is no real humanistic regard here. It is full caseloads, and the system is so overwhelmed that on the ground that means that we treat people, you know, without any great respect. I mean, it isn't just this woman's son's birthday. It is the day she gave birth to that child, and she wants to celebrate with him, and that was denied. You know, like that, it breaks your heart to hear these things. And that was yesterday's conversation. So, you know, I think, you know, we need better supports, and, you know, we know that Aboriginal children have cultural plans done. Now, they're done by majority of non-Aboriginal people. I've talked to child protection workers that go, I'm Googling them, I'm looking online, I don't even know where to start. Now, to get a non-Aboriginal person to write a cultural plan, that is a tick box, quite frankly, and an actual extra reporting burden, administrative burden that people actually don't have a regard for, care about in the scheme of things, because when they look at risk around their broader caseload that is already overwhelmed, the risk is that I need to micromanage the crap out of every person on my books so nothing happens to one of them children, because I'm going to go down for it if it does. Mm-hmm. And there's the shift in accountability and the responsibility around risk. We look at litigation and we disregard everything else.
And what that means for the child protection practitioners on the ground, being completely overwhelmed with caseloads that are way too high to manage, is that they have to prioritise the risk in each of those cases. So they need to make a judgment call about which family is more risky at this current point in time and which one requires my assistance right now. Because if I don't respond to this case, this child might die, or this child might be in a situation where they are harmed. Now, that child protection worker then is feeling overwhelmed and stretched, and they, despite their best efforts, are fighting against this system that's actually enforcing and putting all of these additional demands and pressures on them, and expecting them to juggle these risks and make decisions about which risk requires a more urgent response. For families, that means that your phone calls can go unreturned when you're calling up and you are saying you need some help. For kinship carers, that means that when you're needing support, your phone calls might go unreturned, or it might take days to get some brokerage or some funding to help you buy something like school uniforms for the kids in your care. For myself personally, I have been a kinship care. I was registered as a kinship carer for the Department of Families, Fairness and Housing just recently. We had a situation where we were doing respite and the placement had broken down. They put the young person in our care, an Aboriginal young person, and told us that it could just be a couple of days. We don't really know. We're looking for an alternative placement option. We had this young person for a school holiday period, and we were seen to be doing okay and managing okay. This young person had a lot of complex issues, including disability and significant trauma because they had grown up in the out-of-home care system their whole life and had some horrible things happen in their history. And we were not fully supported to look after this young person for as long as we had to. We were kind of at our wit's end after 2 weeks, it was really difficult. It put a lot of strain on us. But when we would call up and try to get a hold of the caseworker, that caseworker couldn't get back to us as quickly as we needed them to, because that caseworker was dealing with other high-risk issues within their caseload. We were struggling. We couldn't get that support. We had to then draw on the support of our family networks and bring them in and try to help us. But the system creates issues with getting that family support because it expects working with children checks for any child within the system. So if you have any kind of a history where you have a criminal record, it's so difficult to become registered as a kinship carer because that's a black mark on your name. And, you know, it wasn't that long ago where Aboriginal people, if they came into the out-of-home care system, were actually, because it was under the same act, forgive me, I don't actually know the specific legislation, but essentially it resulted in a criminal charge.
Your own child removal, your own removal as a child was listed on your criminal record.
Yes, that's correct. And that's historical, but that's an example of how Aboriginal people have been criminalised historically for no fault of their own. So these issues are all connected with our history, and to unpack them and get to the heart of them, we need to reflect on that history and actually tell the truth about that history.
That's an issue, Dr. Cracker, that you deal with in the submission that you've made with some other academics that make up Safe Start. And I wanted to look at that a little bit more closely. Whilst much of the Australian community views colonisation as a long, distant historical event, your submission draws a connection between colonisation and the contemporary systemic injustice experienced by Aboriginal and Torres Strait Islanders in the child protection system. What's the connection you draw, and how do you see that play out in practice?
So firstly, the connection that I draw, and I don't want to go into the academic theory and sound all lofty and sort of sit up there with that theoretical knowledge base, but the connection that I draw is around this idea that colonisation is not an event, but it is a structure. And so as a result, it continues and is implemented within our systems, such as the child protection system, such as the education system. It is ongoing, okay? So that's one connection that I draw. The other connection that I draw in that submission is that I contextualise the ongoing intervention into family life in child protection and out-of-home care systems historically by showing the intergenerational nature of child removals. So I talk about, for example, the stolen generations as being something historically that happened for whatever reason you want to give it, and the reality that statistically those with a stolen generations history are more likely to have their children come into the contact of child protection systems today. They grew up not receiving love, not learning how to parent in a loving way because they weren't parented well. They were abused. You know, I don't need to go into our history, our mob, and I think largely Australia know this history, right? But they experience so much trauma that trauma continues. And in our communities, that trauma intergenerationally continues. So we actually have communities that are living with this trauma and the effects of this trauma, the effects of the policies that are actually racially based historically. And all of that actually impacts how well someone can kind of provide for their children right now. If I can give an example, if you're growing up, right, and you've heard constantly that you need to be careful because child welfare are going to come in and take your kids if your house is dirty, you are then might kind of become obsessive about making sure your house is super clean and you don't want anything to be used as a potential risk factor when child protection comes along. Or if child protection gives you a call and says, you know, there's been a notification received, we're coming out to do an investigation, that trauma response animates real fear. And you don't want to actually talk to them because you are so scared that it's going to happen to you. What happened to our ancestors? What happened to our elders? What might have happened to your mum or your grandma or your dad? And that trauma kicks off this kind of response where you're so fearful that you don't really want to have child protection in your home, you don't really want to cooperate. Child protection actually then put that as a risk factor, unwilling to cooperate, unwilling to work with child protection in a collaborative way. That is a risk factor for removal, that lack of willingness to engage with the process. It's not a trauma-based response. It's actually this response that just sees the risks, that doesn't understand how the history continues to impact the present, how it actually impacts our families right now. And that's kind of what I mean when I sort of talk about this. We've got to look to the history and we've got to contextualise the current issues within the history. So we need to understand how that history is actually still affecting Aboriginal and Torres Strait Islander people right now.
One of the other things you say in your submission is that as a settler colonial state, and this is a little academic, so I'm going to say to not put you through it, Australia has constructed First Nations childhoods, family life and cultures as problematic, and that First Nations families are punished for not conforming to white Australian standards. Why do you say this dynamic of constructing First Nations people and families as a problem happened in the first place, continues to happen?
Okay. So to answer this question, I'm going to have to talk a little bit about the theory. So settler colonial theory is used by Patrick Wolfe as a way to explain the differences in a colonial context where the settler came to stay rather than to extract or leave. So by came to stay, I mean countries like Australia, Aotearoa New Zealand, Turtle Island, North America. The purpose of colonisation was actually to come and settle the land, to stay. In other countries, such as various countries throughout Africa, the purpose of colonisation was to come and extract the resources, either from the land or the so-called native labour, to use up those people, but not to stay, not to settle in that colony, to extract resources and leave. So he uses this theory to explain that difference. With settler colonial theory, in order for colonisation to be completed, essentially what Patrick Wolfe argues is that you need to eliminate the native. Okay, so you need to eliminate whoever was on that country. When the British came here to colonise or invade, whatever you want to call it, Australia, they declared terra nullius, and that was one act of erasing or attempting to erase Aboriginal and Torres Strait Islander sovereignty. So that was one way of trying to clear the land and clear the problem. When that didn't quite work, we then saw, and I'm sorry to the elders watching, I'm sorry to anyone who's this is going to trigger, but we saw massacres, we saw frontier violence, we saw brutal acts, which you have in my submission, to attempt to clear the native from the land, almost like pests to be exterminated. Okay? When that didn't quite work, when that then turned into the policy of segregation, when we thought that the native was going to die out, we moved them onto missions and reserves out of the way of so-called civilised settler populations to get the Aboriginal people out of the way. And we waited for them to die off to smooth the pillow of a dying race, which the Bringing Them Home report found. When we started seeing this apparent uprise of so-called half-caste Aboriginal and Torres Strait Islander children, we realised that the problem of the native had not been solved. So the answer was to actually, remove that child from the influence of their family, because how they were being raised within that family was seen as the problem. If this child was to have a good future with a good education, with good access to become like other Australians, as stated in the assimilation policies of the day, then that child needed to be removed from the tender influence of their family. Their family was the problem. The way that they were rearing the children was the problem, because it was racialised. We didn't want future white Australia at the time when we had the 1901 White Australia policy in place. We didn't want future white Australia to look like how Aboriginal people raise their families. We didn't want Aboriginal people. We wanted to eliminate Aboriginal people. Okay, and that's something that's hard to sit with, but that's how assimilation links into this logic of elimination. Child removal was the policy that was used to enforce that assimilation and that logic. We thought if we could remove them from their families and from their cultures, they would start acting white, thinking white, and sort of fit in and become like white people.
And that's how we complete colonisation.
That's how we complete colonisation. Yeah, that's how we remove the problem of the native. And we see this kind of anxiety that sits within the nation whenever Aboriginal and Torres Strait Islander peoples assert our sovereignty and assert that we are still here, that we are still surviving. You see it in response and in reaction to, Invasion Day protests or Survival Day celebrations. You see this kind of response, this anxiety that comes out that says, hey, but we belong in this country too. This is our country too. Well, the Mabo decision found that Aboriginal and Torres Strait Islander sovereignty can coexist with Australian sovereignty. Both can sit there. But as a nation, Australia is uncomfortable with this history. And we haven't quite come to terms with it, so this anxiety plays out. What we also see with child protection systems, because our families and our cultures have always been viewed in this deficit way historically, there's still this assumption about Aboriginal people, this racialised assumption about what culture entails, about how Aboriginal people just don't quite parent right. There's this kind of bias that people hold through no fault of their own. It could be unconscious, it could be just a product of the education system or a product of their exposure to what culture might entail. But it results in this assumption about Aboriginal families are somehow riskier, they're somehow more deficient, that Aboriginality itself then in child protection systems operates as a prima facie risk factor for removal.
And do you think we need to properly resolve this, we, as in white fellas, need to properly resolve this sovereignty issue, this anxiety and the sovereignty issue before non-Aboriginal people, before we can break the habit of viewing First Nations peoples and families as a problem to be solved?
I think it's something that we need to do for all of Australia together in partnership, and that's part of what this process is about. The Andrews government committed to this process and totally want to commend the Andrews government on that, willing to actually hear the truth and go through the treaty process. I think we're on the way, but I think this takes partnership. I think this takes us working together, and I think it's everybody's business. I don't think we should be passing the buck to Aboriginal people to solve the issues. I think it's something that we all need to take responsibility for. We need to all check our unconscious bias and actually check our privilege and do the work of actually interrogating whether or not we might actually hold some racialised assumptions, whether or not we might look at Aboriginal families in a more risky way. There's actually a research paper from Aotearoa, New Zealand, that Associate Professor Emily Cadell did with her colleague Dr Ian Hislop, that provided vignettes, which are kind of case studies of situations where there is a little bit of risk. So they were child protection vignettes. So you would start off with a little bit of a story talking about the risk in a child protection case. You would then get fed a little bit more of a story, and then you would get fed the end of the story. And with each level of the vignette, the story became a bit more risky. Now what they did is they gave one sample, the story, the exact same story, with a pakia, so a non-Indigenous white child as the feature of that story. In the other story, it was a Māori child. And they found in that paper that the Māori child was more likely to be seen as risky, and more workers in that study would actually remove that Māori child from their families.
So we put up with less risk for Indigenous children than we're willing to put up with for non-Indigenous children.
Perhaps, or we just see Aboriginal and Torres Strait Islander children and their families as more risky. It could be a combination of both. It's complex.
Thank you, Doctor. I will move on just to touch on, Ms Taylor, you were mentioning earlier unborn notifications, and they are a really huge issue, and I just wanted to go back to that because both of you spend some time in your written submission and outline on that issue, and it's obviously an incredibly important one. Now, unborn notifications are when Child Protection receive a report about a pregnant woman's parenting ability before her child is born. And as I understand it, the legislation does not empower Child Protection to do an investigation until the child is actually born. Where there are issues, they will wait and arrive generally unannounced at the hospital just after the woman has given birth and take their baby at that point. Ms Taylor, this is an issue that you've raised, having previously practiced as a midwife and a registered nurse and now running a First Peoples Health and Wellbeing organisation. What are the problems that you see in this area?
As a midwife working in a hospital setting, you will receive an unborn notification. I'm aware that that same letter will go to every birthing hospital in the broader district. So working in the Swan Hill Hospital, it'll go to Mildura, it'll go to Bendigo, go to Swan Hill, and everywhere else that doesn't birth around the area that might have some sort of hospital facilities where the woman could turn up and try and birth her baby. And they basically get filed away with the expected due date, and they sit there, and when the woman births, the midwife, whoever births that baby and pulls out the woman's details or anything that we might have on file, they will see that there's an unborn notification and they will ring Child Protection. Now, they are mandated to do that. There is no questions, there's no conversation with the woman or her family prior to that. And what I find in the ACCHO sector, so within First Peoples Health and Wellbeing, is there is no shared consent around that information, so we will not be made aware. We are not considered as a key stakeholder in the care for a woman, even if we're providing some sort of shared care antenatal arrangement in her pregnancy. The Koori Maternity Services programs that sit in the ACCHOs are also, and we do not have a funded Koori Maternity Services program, but I have worked in other ACCHOs where there is, and it's effectively a shared care arrangement where you are providing the antenatal care and you will do like the booking in and you send it to the birthing hospital, you'll take them up, sometimes you run the antenatal classes, so that, it can work really well where there's this sort of shared community. I mean, people, their entire pregnancy and postnatal journey, the birth is, this much of the journey. But that's where, that's the key trigger point where this notification goes and it sits and no one talks about it until this baby is born. Now, what we've seen and what I understand with a clinic in the northern suburbs is there is a Koori Maternity Services at one of the metropolitan hospitals who have got some staunch Aboriginal leadership that just do not accept that. And so what we find is that they are holding Child Protection to account in that particular area that says, and because they sit within the hospital, they're sitting in a birthing hospital, and the midwives, because they're also held to account, are sharing that information in a really respectful, consenting way. And so with that knowledge, they are going to these women and saying, there's an unborn notification for whatever the reason is. Sometimes they're substantiated and sometimes they are not. Just the conversation and to bring the mum into the fold can close out that unborn notification risk before the baby's born. Now, if that's
how do you see that? What happens? How do you see that happening?
Can I just quickly explain the legislation, just because I think it helps contextualise what Corinda is saying. So under the legislation, the Children, Youth and Families Act, an unborn notification can be made to the Secretary of the Department of Health and Human Services. So what that means is somebody can say that there is an unborn baby that is at risk, and we would like the Department of Child Protection to be aware of that risk. But under that legislation, Child Protection cannot substantiate a case while the baby is in utero. So while the woman is pregnant, that case of potential or alleged child maltreatment cannot be substantiated. The power to substantiate that notification and to conduct an investigation that actually links in and enables the substantiation to take place has to wait until the child is born. So the result is, on the ground, that Child Protection, when an unborn notification is received, will defer to community support services, and they will make referrals to other services because they have that power within the legislation. So they might defer to a community support service such as VACA to provide support for the mother and the unborn child during pregnancy. And Child Protection will send out the letters to the hospitals to alert them to the birth of that child, so that when the child has been born, they can investigate and they can potentially substantiate if they're concerned about the level of risk. What that means in practice is that we have mums who have Child Protection show up within hours of them giving birth, and that is the first person that they see outside of the midwives. The first face that they see when they were holding their newborn is a Child Protection worker. And because Child Protection actually cannot substantiate or conduct official investigations in utero during pregnancy, they are concerned with this concept of flight risk. They are concerned that if they tell the mother that there is a notification, she's going to do a runner. She's going to go to another state, and we know that Child Protection systems operate differently in each state and territory, that there are different pieces of legislation, so they don't actually connect very well together. They're worried that she's going to take off and they're not going to be able to protect this child. So they use this concept of flight risk as a way to justify not actually being transparent and not actually communicating the risk to the mum. And the result is that the mum sometimes doesn't know that this is coming. The midwife legally is not allowed to tell the mum why the notification has been received. They can tell them that a notification has been received, but not why, and you have that information within my submission. They will then need to... So the reality is that the support that is actually received during pregnancy is not from the Child Protection system. It's received by Child and Family Support Services, and quite often the reality of what is happening on the ground is it's received by the health system. So people like Corinda and First Peoples Health and Wellbeing are doing all the support during pregnancy, and they're having to do extra things that they're not funded for to try to prevent Child Protection from taking this baby once the baby is born. But they're not funded to do that.
Right.
Can I just add to that? I think the other thing around, keeping the legislation around not working in that unborn space means that they don't have to put money in the front end and so that preventative stuff. And I think as an Aboriginal organisation, when we aim for culturally safe, trauma-informed, genuine wraparound care that is considered, that is calm, that is nurturing, this system in itself creates, after the baby is born, a sense of urgency and chaos. It is traumatising. And, we just, it's really frustrating because you can see that they use, the department uses the legislation depending on what their narrative is. So they use it as an absolute restraint from going over and above. And the reality is Aboriginal organisations go over and above all the time because there's no interest like self-interest. And as Aboriginal people leading this work and we're supporting Aboriginal families, we will bend over backwards. Postnatal care in career maternity services till 6 weeks. We'll look after families forever and a day. The funding will not restrain that. It is a minimum standard. It's not a maximum standard. But it's actually used as, no, we're not allowed to do that. No, the funding's not there to support that. No, we can't triage that. And I understand that, the legislation should support families that, while she's pregnant, leave her alone. and you can't necessarily investigate. We're not asking for an investigation, we're asking for a conversation. We're asking for a genuine conversation. And even in terms of the flight risk, I can tell you if I was pregnant and Child Protection came at me with an investigation while I was pregnant, I'd probably run too. Had my supported, trusted healthcare provider talk to me about a notification that is going to rear its ugly head when I give birth, I am going to engage and I'm going to go, what needs to happen? And I can give you an example of something that was a case study where had there been a conversation and an understanding of the woman's circumstances, the book would have been closed before the baby was born. But instead, the first person she sees, and this is the example, is the first person that she sees before any of her family arrive to meet her new baby is a child protection worker to take her child. She was unaware that the notification had been made. It had been made by the police at 5 weeks pregnant after a blew with her boyfriend because the neighbours rang up about the noise disturbance. And so for the other 8.5 months, it goes undiscussed, unrecognised. They turn up to take the baby. She is no longer with the partner because of family violence. She has a place of her own. She's getting help to work through the trauma of the family violence. There is zero risk here. And she is absolutely embedded in this continuity of care at our service, yet she had to go through that because no one asked her what her situation was now.
And you have that in our submission that we made, that a lot of these risk factors in the unborn and infancy period are actually historical and static. So what that means is that if you have an out-of-home care history yourself, you were in out-of-home care as a child, and then you fall pregnant, that's a risk factor for Child Protection to get involved. If you have a mental health history, you have past suicide attempts in your history, that's a risk factor. If you have intellectual disability, and it might be present, this is a factor, though, that you can't change. So a lot of these risk factors are historical and static, meaning that no matter how well motivated some families are to actually do their best to address any of the risk concerns, they can't change their past. You can't change the fact that you live with an intellectual disability. That just is. But the system is concentrated on risk in this infant period because babies are developmentally dependent. They are at the highest risk of dying through neglect or through child abuse because they're developmentally dependent on another for life. And that vulnerability of a baby then creates this crisis response to come in and quickly investigate as fast as you can, because if you don't, that baby could die. It then also means that the system's not willing to actually take a chance and maybe try something where there's a lot of strengths and there's a lot of protective factors. There might be a little bit of risk, but it's not willing to try because if it doesn't, if something goes wrong, someone's liable, a child's going to die, it's going to be awful. It doesn't want to take that chance. And there's research literature that backs that up, that shows that in the UK, and this has nothing to do with Aboriginal or children, but social workers were more determined to, they were more likely to err on the side of caution. And they would rather do that because the alternative is grave. But as we've kind of been talking, for Aboriginal and Torres Strait Islander families, our Aboriginality is actually also used as this kind of unique risk factor in and of itself. In a research study published by Associate Professor Melissa O'Donnell, which you have in my submission, she contributed to the Safer Start Coalition submission. It was from 2019. She looked at administrative data in relation to Western Australia and found that even when they controlled for all of the other risk factors, like substance use or family violence or a lack of stable housing or disability, Aboriginal infants were almost twice as likely to be removed by Child Protection.
In this, as you say, there is an undue focus on risk. It seems in some ways that there's really just an undue focus on certain kinds of risks, because your PhD looks at cultural connection in out-of-home care. It seems that the very grave risks that come with removing a child from their family don't really get a showing in this risk assessment, that it really is just a focus on the risks of staying in the family.
It's an interesting one. Child protection decision making is inherently complex, and what it does is it looks at the most immediate and pressing need and the risks that are most at play at that current point in time. What is required right now to keep that baby or that child safe? We're prioritised on the best interests of the child. We're prioritised on keeping that child safe. So we respond to the immediate risks that might put that child at risk of harm in the now. What it does, though, by its nature, is in responding to those risks, and responding to those areas where there might be harm, it actually then trades off that for another form of harm. And it's well known, it's the harm of living in the out-of-home care system. That harm of being disconnected from your family, community and culture. And the harm of that potentially being something that becomes long-term. And if you look at our history of the stolen generations and the harm that our community members felt as a result of removal, it's these lifelong challenges around identity and belonging and finding your place and learning about your culture, about knowing your mob, about knowing who you are and where you belong. It may not have been, and this is the case, it's what I found in my PhD, it's still happening today. There are children in the out-of-home care system where we take them out from their families because there is an immediate harm that needs to be responded to. So the child protection system removes them. They then place them into out-of-home care, which is its own kettle of fish and a different system that has a lot of complexity behind it. But along the way, with the checks and balances and lack of transparency and lack of accountability, the system is actually producing another form of harm. It's producing the risk of cultural disconnection. And that's a harm that's not just felt at an individual level, that's felt at a community level. That's, for us, our culture is our survival. That's our proof that we are here and we are thriving. Our children are our future. Our children are the key to our culture's surviving. Now, when you create the risk of cultural disconnection, what you are doing is you are fundamentally creating a system where you're perpetuating another stolen generations. That's what you're doing, whether intended or not, because these are complex decisions. They are so complex, and I can't overstate that enough, how complex it is. But what I do need to say is that because of the way the system operates, because of the funding allocation, because of the services that are in place to support Aboriginal and Torres Strait Islander families at the moment, and because of the legislation and the way in which the bureaucracy works, what we also have is a situation where it's not just the state that's perpetuating this harm against Aboriginal and Torres Strait Islander peoples, perhaps as individuals, perhaps as collective, but it's our own organisations that are also perpetuating this harm.
In what way is that happening?
I'm saying that it's happening through the use of Aboriginal community-controlled organisations who are bound to the legislation and need to act in a certain way when children are placed in out-of-home care. They have certain checks and balances that they must respond to. They have high caseloads as well, and they have to respond in certain ways. They have carers that, perhaps, and we saw it in some of the previous evidence, that people might perceive or describe as racist, or perhaps what I found in my PhD, they just lack knowledge of the complexity of Aboriginal and Torres Strait Islander cultures because we're so diverse. And perhaps they're not supported along the way because the system's trying to respond to another risk, or it's trying to respond to another child in a more dire circumstance. So it's looking at these immediate harms that are happening, and it's not able to respond to these potential longer-term harms. It's not able to actually wrap the support around the foster carers and the kinship carers to ensure that our children are connected to their families, to their communities, to their cultures, and have the right to continue connecting and find themselves, to be supported in their journeys of culturally connecting. And you have the evidence in my PhD thesis that showed examples where children's own, their own families, their non-Indigenous side of the family, because the Aboriginal and Torres Strait Islander Child Placement Principle places Aboriginal and non-Indigenous family at the highest level of the placement hierarchy. That's why it's compliant. The non-Indigenous side of the family might hold very negative views. You know, in the case of a few of the participants from my PhD study, the non-Indigenous family members actually held some very racist views about Aboriginal people. And fundamentally, we all learn culture through immersion in culture. We learn it from the people that are around us. So when you're hearing these negative perceptions about Aboriginal people, or you're hearing this media discourse that constructs Aboriginal people in a particular way, you're then internalising that. You're finding that difficult. And it's challenging because ultimately when you're in a statutory system, the system has the responsibility to come in and to make sure that children are getting everything they need to be immersed in culture. But it can't, because the system's in crisis.
I wanted to move on because there are a lot of really great issues that both of you cover. The third issue I wanted to ask you each about is strengths, about the strengths of Aboriginal women and families. Ms Taylor, in your outline of evidence, you state that there is a need to embed a positive, strength-based approach to working with Aboriginal families. Firstly, what is a strength-based approach?
I think about unconscious bias. So I think in terms of, you know, our individual upbringings, and, you know, it probably goes back to that original first bit we talked about around, you know, what constitutes good parenting. You know, in the case study with the woman that come and did the 10-day assessment, you know, even just the language that was used, recognising the strengths in the woman in terms of you might not necessarily not like or agree, or you wouldn't necessarily act in a certain way, but to recognise that within that family dynamic, you know, just being able to interpret the information. It's actually a really, it's a big topic. I think having a genuine understanding about the importance of an Aboriginal culture within a family, within the broader family, beyond the nuclear mum, dad and the child, you know, there's actually very little regard for the broader network of a family. And the strength of what that collective can bring is rarely recognised because it looks at the one individual, and it's often the mum as opposed to dad or nana or an auntie in the broader family. And even just the language use, so being able to, you know, like stereotypically sort of pigeonhole your expectations. So as someone's talking to you, there's very little demonstrated ability to use that information and then structure it in a way that would allow a strength-based outcome within the report. So the reports are written in a really negative way.
If I can give a practical example of that, if you have a mental health history, right, and you have had past hospitalisations, inpatient admissions, past suicidal ideation, or past suicide attempts, instead of looking to the resilience and what it's taken for that person to survive, the fact that they're still here, the fact that despite all this trauma of the past and all these challenges, instead of looking to how that actually could be conceived as this strength of the person, the child protection system will see that as a risk. There is a potential there for that person to have an exacerbation of an existing mental health condition. They could potentially become overwhelmed. We could trigger them. That's a risk factor. Instead of seeing, what has that person survived and what are they doing today? They're still here, right? They might have been through some horrible, traumatic stuff. But this is the difference, I think, between the health system and the child protection system. The health system comes from this strengths-based perspective where it's focused on the holistic needs and well-being of the entire family, the child, the parents, and the family in the broader sense of the word, whereas the child protection system, as a result of the best interest of the child principle, focuses on the child as their primary client, and they will focus predominantly on the parents as those who hold the legal guardianship of the child before that legal guardianship is contested within the court system.
The last question I wanted to ask before we go into closed session was one for Dr. Cracker. Earlier this week, the Premier indicated that the government would devise a new child protection system for First Nations children and families. Did you see the comments made by the Premier, and did you have any response to them?
Firstly, I think I absolutely welcome and love that idea of creating a new child protection system. I think that's the right way to be thinking about this issue. What we don't need is reform after reform and recommendation after recommendation, because we have seen that that doesn't work and it hasn't worked. So I think fundamental structural transformation of the system is exactly what we need. And what we need to be thinking about is how can we do that structural transformation in a way that upholds the principle of Indigenous self-determination, paying attention to the rights of the individual and the community, as well as the complexity of Aboriginal community politics. How can we do it in a way where the government works in partnership, not just with Aboriginal leaders and Aboriginal organisations, but how can we do things new and innovatively and differently? How can we reflect the lived experiences of those who have been in the system? How can we ensure that Aboriginal children and young people actually get a voice and get to offer their solutions and get to offer their new ideas of what this new system could look like? I don't hold all the answers, but community knows what they want their child and family welfare system to look like. Community knows what's in community's best interests. So we need to think about how can we get these grassroots level voices? How can we mix up the funding? How can we spread it out to a bunch of new different Aboriginal organisations who might want to get into the child and family welfare space? How can we think about young people actually coming up with creative solutions driven by their own expertise of living in the system? If I can give an example, I was at the Queensland Aboriginal and Torres Strait Islander Child Protection Peak Conference last week, QATSIP for short, and there was this amazing youth organisation called Deadly Indigenous Youth Doing Good. And these were young people who had experience of the system, had grown up, and they gave their keynote about how they were doing things differently and innovatively because they could imagine an alternative future. They could imagine something that worked differently. And they were achieving these positive, fabulous outcomes. They were doing things really well. But we need to tap into new ways of doing things. We need to actually tap into building up an Aboriginal-led evidence base. We don't really have a very strong Aboriginal-led evidence base in Victoria. So we need to be thinking, okay, how can we actually create an evidence base around, an Aboriginal-led evidence base around the concept of the best interests of the child? What might that look like from an Aboriginal and or Torres Strait Islander perspective, and how might that differ from a Western perspective of the best interests of the child? What do community want in terms of self-determination? How do they want to be self-determining? What do they want to see? And let's engage broadly. Because I think governments, and I know a little bit about how policy works, is when we are devising policies, and I'll say this as someone who was on an expert reference group for the creation of the National Framework for Protecting Australia's Children 2021 to 2031. We engage with this expert Aboriginal advisory group to advise decisions and to then sort of inform what that policy might look like. We then might go out and do sort of broader consultations, collect that, and then sort of come back to the table and try to devise a policy solution. I think what we're doing is we're not consulting widely enough. We're having, often the same people come into those circles and making those decisions and doing those negotiations with government. Let's think about how we can bring in new, fresh ideas and voices into those arenas. Let's think about how we can mix things up. Because if we want to break this problem, We have known for a long time that the child protection system in Victoria is in crisis and that it's not working properly. We know that the numbers of Aboriginal and Torres Strait Islander children in out-of-home care continue to rise. We've done inquiry after inquiry. We know it's not working, so we need new solutions. We can't keep doing the same thing. We need to think, how can we do things differently? And I really honestly believe that there is a lot of goodwill within the Victorian government, and I think there is genuine commitment to the principle of Indigenous self-determination. I just think that perhaps they've been receiving the same advice, or perhaps they've been given solutions that don't work, that are not fit for purpose, that are not place-based solutions generated from grassroots community members from the ground up. Perhaps they've been hearing things that just don't quite work. Doesn't mean that you should say that Indigenous self-determination and Section 18 as a principle doesn't work. It's just that we haven't quite found the right way to do it. Because the system's so complex, we can't expect that if we do one thing, it's going to produce a particular outcome. We've got to be willing to have a little bit of policy failure along the way and respond to that. And then mix it up, do things differently. And I think we can do that. I think we can think about perhaps taking a public health approach. But I also think that we can't do it in isolation. We need the partnership of the Commonwealth Government, because the reality is that universal support services, poverty alleviation strategies are also the remit of the Commonwealth. We also need the partnership of all Victorians. All Victorians. We need our allies. We need people to come on board and come on this journey and be open to challenge unconscious bias, be open to reflect and to think about, if they're a mandatory reporter, how do they perceive Aboriginal children? Do they perceive them somewhat differently? Do they not realise that they're actually seeing this Aboriginal family in more of a risk-focused way than a non-Indigenous family? Because the problems within child protection are not just within child protection. Child protection intersects with a range of different systems. It intersects with the family violence system. It intersects with the police. It intersects with the health system. It intersects with the school system. It intersects with any system that has a job of essentially surveilling or monitoring or looking out for the well-being of children. And that's all of society. So these are societal issues. They're not going to be fixed with an easy policy, quick fix solution. I can't give you a quick magic tool that's just going to go boom, fixed. It's something that's going to take time. It's something that's going to require complex thinking and, new innovative solutions to generate solutions too. But it's worth it ultimately, isn't it? Because we all care about the safety and well-being of our children. And I think that's something that we need to say, is that no one wants to see something bad happen to a child. No one wants to see a child harmed. We don't want to see a child harmed. But it's how that is done, how that protection of children is done, that is so hurtful and so damaging, because it's done in a way that's punitive, controlling, coercive. It's done in a way that feels like punishment, and it's done in a way, and it's been written about in the research literature, it's being done in a way that makes families feel like this is not a child protection system, but it's a family policing system. There are magistrates and court orders and police coming in and telling families, your child is at risk of harm and therefore they are subject to removal. That's coercive. The full force of the law is brought down upon these families and they have felt powerless. And without a system, someone to advocate for them within this system, their hands are tied. The system holds that ultimate power to decide whether or not that child should be removed. And that power is felt by families who are traumatised, who are struggling, who are really doing it tough. And they can't fight that. It beats you down. It beats you down. It beat me down as a worker in that system. That's why I got out of casework, because I felt beaten down by the limited amount of change I could affect as an individual in that system. I wanted to get out of that system, get to a position, and I am so thankful for the educational privilege that I have now, where I'm in a position to have my voice heard. But we need to think about structural transformation. What can that look like? And the possibilities are limitless.
Thank you, Doctor. We were very quickly going to go into closed session, really just for one or two questions about issues that were particularly sensitive. So we might just pause. Chair, I make a request that the live stream come down for a short period.
Council, could I just ask a question before?
Sure.
Before? Dr. Cracker, you talked about or mentioned the best interest in the framework. It's in legislation. So the best interest of the child. Is that self-determination?
That is a really loaded question. That is a complex question. I think the best interests of the child, the way it's operationalised, is a focus on the individual child and their needs and their rights to safety and wellbeing. I think that self-determination for the individual child, potentially, could be achieved through the best interests of the child, but the self-determination of the family and the community isn't upheld through that best interest principle. And that's because the best interest principle has its location in this idea of children's interests as being divorced from family, community, country and culture. It has its traditions in this Eurocentric way of viewing children as separate to families, as an individual agent in and of themselves, whereas we don't see our children like that. We see our children as an individual, yes, but also our child as future, our child as community, our child as belonging, our child as interconnected to this complex kinship system. And I think that's where there is this kind of cultural misunderstanding of Aboriginal ways of child rearing and parenting that actually confound understandings within the system and limit the application of Indigenous self-determination. Because that's also a very complex concept as well. It's understood from a political theory kind of way, it's understood from a legal way. So there's a lot of tensions and a lot of complexity, but I don't think the best interests of the child principle actually enables full Indigenous self-determination.
Thank you. Thanks, Council.
Other commissioners content?
I just have one question of the many I'd love to ask. You mentioned that a reform, Dr. Cracker, you mentioned that a reform system could take a public health approach. Could you just explain briefly what you mean by that?
Okay, so within the research literature, probably since about 2006, we've talked about this public health approach to child protection systems or child and family welfare. If I can give you an example, it was enshrined in the National Framework for Protecting Australia's Children, the previous version to the 2021 to 2031 example, and it had this triangle of what a public health response could look like. So a public health response is about understanding those universal supports that are available to all families, such as childcare. So if we have free or subsidised childcare, that's a universal that could be available to all families to help alleviate some of the stresses and some of the hardships and some of the challenges of child rearing. We then have a secondary level of support. So when a family starts to sort of become at risk and might need some help, and they might go to a targeted service, such as a counsellor, for example, or they might see someone attached to the National Disability Insurance Scheme and get some support around disability or a child who might be on the autism spectrum. You then have your more targeted levels of support, so your families who are high risk, at risk, so you might have your family violence support services, you might have your intensive substance use services. And then at the tertiary level of the system is the child protection system. That is a tertiary level response. What I'm saying in terms of having more of a public health response is that we need to shift the investment and invert that triangle. So currently the expenditure, and I'm sorry I'm going on old data, it's from 2019, but at 2019 a research report found that of the nearly $6 billion spent annually on child and family welfare systems, only 17% of that went to early intervention and sort of preventative measures. And I'm saying what we should do is flip that investment to think about poverty alleviation strategies, ways where we can actually prevent children from entering the tertiary end of the child protection system and actually stay in those lower levels of support to actually build up the protective factors and the supports and wrap them around the families before the risk gets too high, where it gets to that threshold where the system then feels like it has to intervene.
Thank you.
Look, I just wanted to thank you for that extremely articulate and evidence-based and grounded in your community and your identity of what you've done with families. And I think the thing that really struck me, that you actually put it in really how the system is systematically stacked against Aboriginal families and children, with that combination of the disproportionate need and that structural bias that is built in at every step along the way. And I just thought that was a beautiful way of encapsulating why we see what we do. So thank you.
And I think too, just to add on that, when we understand the system in that way, we understand it as a systemic issue, and we don't blame individual people.
No, neither.
It's not an individual's fault. They're actually part of this system, and this system has an issue.
I don't have any.
I'm very happy to have all of the non-closed questions, and now rather than disconnected at the end. So if there were any further questions about the open session issues.
I don't know.
Thank you, Commissioners. Could we bring the live stream down?
Yes. Yes.
Just take a moment.
We're on the air, are we?
Yes, we're ready.
Thank you, Commissioners. I call the next witness, Mr Ian Ham. Mr Ham is in the witness box. Mr Ham, can I ask you to tell the Commission your full name, please?
Yes, my name is Ian David Ham.
And you've provided an outline of evidence to the Yoorrook Justice Commission.
Yes, I have.
And you've read that document recently?
I have.
To your recollection, is it a document dated 7 December?
To the best of my recollection, yes.
And the evidence contained in that document and your evidence here today is to your knowledge the truth, will be the truth?
Yes, it is.
Thank you. How would you like to be addressed? As Mr Ham?
Ian's fine. Or Mr Ham, whichever you would prefer.
I'll call you Ian if that's okay.
It's fine with me.
Ian, could you just explain to the Commission who you are and where you're from?
Yes, so my name's Ian Ham. I'm sitting here in the role as, or one of my roles, many roles, but mostly as Chair of Connecting Home, Chair of the Board of Connecting Home, which is the Stolen Generations Service in Victoria. I was in the public service for over 32 years for the state and federal governments across a range of portfolios, but mostly connected to Aboriginal affairs. And these days I'm a non-executive director, among other things.
And your traditional country is where?
I'm a Yoorrook man.
From any part of Yoorrook country in particular?
Yet my family's from Shepparton, although I grew up in Yarrawonga. I was one of the stolen children, so I grew up away from my birth family and grew up as adopted to a non-Aboriginal family, the Ham family.
Did you want to just describe for the Commissioners the circumstances of your upbringing as a stolen generation survivor?
Certainly. So I was separated from my family at 3 weeks of age, actually here in Melbourne. So I was born at the Royal Women's in Carlton, and I was adopted in September 1964 and grew up in Yarrawonga, one of 4 children, 3 of which were Aboriginal. My adopted parents adopted 2 other girls, one who's a year younger than me and one who's was 4 years younger than me. No relation as such, or actually one of those girls actually turned out to be a cousin, a 4th cousin, which was one of those things when you realise you are related to someone. It was kind of like, oh, we really are related. But in any case, we grew up in a town, 3 Aboriginal kids in a town of about 3,500 people, 3,500, and the 3 of us were the entire Aboriginal population in Yarrawonga.
And at what point were you able to meet your family?
Yeah, that came around in I was always aware I was Aboriginal. Mum and Dad, my adopted parents rather, had always encouraged our Aboriginality without knowing what that meant. I first started inquiring as my background in 1983, when I was 18 and a half, and I moved to Bendigo to go to Teachers College in Bendigo, and met some people there. And one of them, upon asking who I was and what I knew about myself, looked at me and said, "I think I know who you are, leave it with me." 6 months later, somebody got back to me. That was when I first come across the concept of Koori time. It takes a while. He said, somebody get back to you quickly. It was 6 months later, but eventually it was someone from ACCA, or the predecessor of VACA, came up to Bendigo and met with me and took me through my story of who I was and where I was from.
And what did you find out about your family?
I found out that I was from Shepparton, which up until that stage I didn't know where I was from. I thought, am I from North Queensland? Am I from Central Australia, perhaps Western Australia? And I was from Shep, which was 50 minutes in the car. So it was about, 35 mile away from Yarrawonga. So in one sense, I hadn't gone anywhere in my life. in another sense, I could have gone to the other side of the planet. I didn't know that that was where I was from. And I only discovered that I actually had grown up on what was my traditional lands after I left Yarrawonga.
So looking back on that today, how do you feel about it? What emotions does it stir? It
probably doesn't, it stirs an emotion of what might have been rather than trying to describe an emotion of happiness or sadness. It's more an absence of what might have been. I do, from time to time, reflect on that. I had my formative years somewhere else to the rest of my family. And that shows up at little time, at times too. Family celebrations, birthdays, and people talk at those things about when they grew up together and what it was like. And I grew up somewhere else. That's where it emotionally shows up the most for me.
And so is it your experience that, try as you might, the factual realities can't be bridged? That you weren't there for those things.
Yeah, I can't change that. I think a way of coping with it is to do what I do or what I have done with my working life is a way for me of coping with it, rather than letting it get the better of me. Trying to do something positive.
And I might take that opportunity to ask you now about your work with Connecting Home as the chair of that organisation. Can you just describe what that organisation does?
Yes, so Connecting Home is the prime Stolen Generations organisation in Victoria, support organisation in Victoria. It was established in 2010 when the previous organisation, Stolen Generations Victoria, ceased to exist. Connecting Home was established. I was the inaugural chair. I set it up basically, and it now continues and is in fact expanding in the service model it operates. We're primarily a client support agency. We look to provide a wraparound service to our clients, but we also provide a key. We look to focus on having influence across policy and advocacy and information and education to do with stolen generations as well.
And just to be clear, your clientele are stolen generation survivors?
Our clientele are stolen generation survivors, and in a lot of instances also their descendants as well, particularly their children and grandchildren in some of our clients' cases.
And whilst it might be the case that some of their, and often is the case, I imagine, that some of their children and grandchildren are subject to the child protection system today or have been, the role of Connecting Home is not providing services to the current cohort. It's only the stolen generation survivors.
Stolen generation survivors, however, we do work with descendants in some capacity in some things, but it is primarily focused on survivors themselves.
And that, I think at paragraph 5 of your outline is those people removed before 31 December 1976.
1976. That was the date set by the group that developed the Stolen Generations Redress Package in Victoria.
And do you see a difference between the stolen generations as described and what's the people who are going through the child protection system today?
There is a difference in the beginning, if you like, of what individuals go through. So if I think about what we term the stolen generations, children removed simply because they were born Aboriginal. Rather, we were born Aboriginal. That was primarily what the stolen generations and the mass removal of children was about. Being born Aboriginal, and it was not just a government policy, it was a societal expectation. Governments only reflect the societies in which they operate. It was a societal expectation that children would be removed so they could be brought up away from their family, culture, community and their country so they could perform or be useful contributors to the dominant society. That's what it was. Now, children are removed for a range of reasons, but the prime one is it is not driven by they are simply Aboriginal, we have to take them. That's the fundamental difference. Having said that, the experience once they are removed can in some cases be not too different, and the consequence of if that experience is not a good one or one that is managed in an appropriate way, the consequence can be the same. That is people who are disconnected from their country, their culture, their community, their families, and therefore they lose their identity, is just as much an outcome now as it was for previous generations.
Thank you. And I can tell you that the Commission has heard evidence from a number of witnesses this week who are stolen generation survivors, and at paragraph 7 of your statement, of the outline of evidence, it records the loss of culture that survivors of stolen generations experience often leads to a loss of personal and social identity. Many adults spend their lives not only trying to reconnect with their families, but also with their culture. And that's a broad generalisation, but it's one that holds fairly well for your clientele?
It's one that holds pretty well for the whole stolen generations community, and not only in Victoria, but around the country as well. So it's an ongoing process for virtually everyone. And part of Connecting Home's responsibility or work is rebuilding those connections, or helping people to rebuild those connections and find peace. Is Yes.
the way it's put?
Yes, yeah. In my statement, I referred to it as peace. There's no other way to describe it. At least getting people to a point where they feel their life isn't in a constant state of flux and change and turbulence, centred around who am I and where do I fit into the world, whether it's my family, my community, or connecting with other stolen generations people that you have a common experience with. That's, I guess, philosophically what we try to do, and the programs and things that we do go towards that end.
And it's not the case, is it, that that Connecting Home engages and provides services to clients, and then they're off on their own. You don't see them again. It's more often that they come back at times of need.
They do. We have some clients who've been with us for many years. We also have clients, and this would be a not insignificant number. They get to a place where they're okay, and then we don't see them for 6 months, maybe a year, and then they'll come back because their life was not going as well as it was when they were okay, and they've become unokay, if excuse the poor English, and then they find that they need our help again, and that's okay for us. That's what we're about. Our approach isn't a treatment-based one. It's a support one when people need support.
And, Connecting Home has also picked up some other responsibilities.
We have also become a registered NDIS provider as well, because it doesn't take much logic to work out that people who've been through a life of trauma quite often have a whole bunch of other issues, in this case those which draw their eligibility to the National Disability Insurance Scheme. So we took the decision to become engaged in the NDIS directly to make it work best for the people who need our support.
And you've also had, Connecting Home also has responsibilities in relation to the Victorian Stolen Generations Reparation Scheme, the National Redress Support Services, and a Stolen Generations Funeral Fund.
Yes, we have.
Can you just speak briefly about the funeral fund and why it's necessary?
Okay, so the funeral fund was established upon the announcement by the Premier and the then Minister for Aboriginal Affairs, Gavin Jennings, that the State of Victoria was going to develop a redress scheme. And it was an acknowledgement that stolen generations people, a lot of our people don't have don't have any economic circumstances, and they were basically dying as paupers, and their families not being able to afford funerals. And so the distress of people who've had a basically rotten life, them being buried as a pauper, it was put upon the government to establish a funeral fund. So if people didn't have a decent life, they could at least have a decent burial. That arrangement was worked out with the government in Connecting Home, and Connecting Home manages the program, where we provide up to $10,000 per funeral.
Thank you. I just want to ask you some questions about the Healing Foundation. You're a board member on that organisation?
I am a board member.
And you've done some work particularly for that organisation as chair of its Stolen Generations Reference Group and chair of the Historical Records Task Force.
Yes, I have.
And they're discussed in the statement. The Healing Foundation, just for the record, could you just describe what the Healing Foundation does?
Yep, the Healing Foundation, if you like, is the national focal point for Stolen Generations people. It provides policy research, advocacy, working with other entities around Stolen Generations mechanisms, Stolen Generations services, what it can do about influencing what other governments and other agencies do in relation to Stolen Generations. That's a really high level thing.
And so, in large, is it fair to say that primarily it's an advocacy?
Advocacy body, yes. So, to be clear, the Healing Foundation doesn't do direct client service. As a national body, our role is more a strategic one, and we seek to provide the national focus, as I said, working with the federal government and, where appropriate, state governments, and also other Indigenous bodies and non-Indigenous bodies around supports for Stolen Generation people.
At paragraph 12 of your statement, in the last line, you talk about there not being a lot of data for Stolen Generation survivors, and that really before 2018 the data wasn't there. Can you just explain that a little?
Yes, so up until 2018, it was actually in the lead up to the 10th anniversary of the apology by the then Prime Minister Kevin Rudd, the Stolen Generations Reference Group of the Healing Foundation were asked by the foundation, what should we do for the 10th anniversary? Should we have a dinner? Should we put on a concert? And we actually said, while that's good, one of the questions that hadn't been answered was, how many Stolen Generations people are there? Nobody had actually asked that question. And so the Healing Foundation commissioned some work through the Australian Institute of Health and Welfare to look through established data sets to see, can we identify the numbers of Stolen Generations people in Australia? Hence, that's where that work came from in 2018. And it was updated, I think it was in 2021, the data was updated up until 2020.
Thank you. I just want to ask you a couple of questions about the Stolen Generations Reparations Steering Committee. You've included in the statement some detail about that work, which is no doubt very important work. And following the recommendations of the report from that committee, in March this year, the Victorian Government opened a reparations package.
They did, yes.
And what was the nature of that package?
The nature of that package was, in essence, to provide financial compensation for an apology to be provided by a minister or a departmental secretary, a personal apology to each applicant or each person who was deemed to be eligible for the settlement package. And also, it made recommendations around programs and services and supports for descendants of Stolen Generations people as well.
And are those supports being provided?
I'd have to say we're probably still in the beginnings of expanding the services that we already have established, such as Connecting Home, and probably beginning to identify what further services are needed and how those are going to be resourced.
Now, I just want to ask you quickly about the payment, the amount of the payment. What was that amount?
$100,000.
And what's your view about that payment?
That payment, I think, is significant enough in terms of, I'll put this a different way. We live in a society and a community that puts a dollar value on people's distress and pain. Whether we agree with it or not, that's just how our society works. This is an amount of money which, in the view of the committee, given the budget that was available to us, was what we determined to be an appropriate amount of money in recognition of a life not lived, of the complete dislocation, disruption to people's lives from birth in some instances or from early childhood. So the $100,000, while no amount of financial compensation can ever compensate for a life lost, this was looked at as significant enough that people could see their experience had been acknowledged.
And how did that amount compare to other jurisdictions?
It's the biggest amount compared to other jurisdictions. Tasmania's was around the $10,000 mark. South Australia went $15,000. New South Wales had a graded scale of impact of being taken. They not only looked at removal, they looked at what was your life experience and then graded that and made a determination on how much you got as a result of that. The Commonwealth scheme had $75,000 plus an additional $7,000 for counselling support, so that came to about $83,000, and the Victorian one is $100,000. The challenge for the two jurisdictions remaining to do it, Western Australia and Queensland, is to up the ante again, which may necessitate every other jurisdiction revisiting what we have done.
Thank you. Now, you have, over the years, given evidence in a number of inquiries.
So can I ask a question now on this very subject?
Certainly.
I think I understand the figure to be arrived at by dividing the approximate number of stolen people into the available budget.
Pretty much. It wasn't a great detail of mathematics, but it was. We estimated the amount of people we had in Victoria who'd be eligible under what we were thinking to be the criteria against the amount of money we had and other provisions we had to make, and that's how we arrived on $100,000.
Has there, and I don't think that any attempt was made by you to, as it were, calculate according to a compensation principle the amount that would be paid if true compensation were to be awarded, say, by a court or tribunal?
No, not at all. Our job was to, with the available money, how far we could make it go, but at an individual level, which would be significant enough so people felt like
meaningful.
It would be meaningful.
It would be meaningful.
Yeah.
And my understanding is that exercise of estimating according to a true compensation principle would be the amount has never been undertaken. Not as that I'm aware of in the Victorian jurisdiction. I don't think it has been anywhere else, although there is a case in the Northern Territory. I'm not sure the outcome of that. Thank you, Counsel.
I'll just ask the witness a further question along that line, Commissioner Bell. Are you aware of the decision in Trevorrow?
Yes, Trevorrow, yes.
And do you know the amount of compensation paid in that matter?
It was more than $100,000. I'm not sure of the amount though, but I remember at the time. It was pretty impressive, but I also was aware what the applicant had to go through to get that, and that took a lot of courage, but was quite costly personally.
If I might take the liberty of reminding you a little, it was a South Australian matter, the Trevorrow family, and the figure was something in the region of $500,000 for damages. But he had a lengthy court case.
A lengthy court case, yes.
Now, does that raise any further matters for you, Commissioner Bell, before I move on to the next topic?
No, thank you.
Now, you've given evidence in the forced adoptions inquiry, the Joint Select Committee on the implementation of the National Redress Scheme, the Royal Commission into Aged Care Quality and Safety on the stolen generations? Or have you made a submission in relation to that matter?
Submission was made, yes.
And Connecting Home, together with the Victorian Office of the Public Advocate, made a submission into the Commonwealth, the Royal Commission into Violence, Abuse, Neglect and Exploitation of Peoples with Disability.
Yes.
Those submissions are attached to your outline of evidence.
Yes, they are.
They're available for the commissioners to
They are indeed.
consider. What I wanted to do is take you a little bit further through your outline of evidence. Commissioners are moving to paragraph 37, where you talk about the changing demand for housing and your knowledge of the housing needs of Victorian Aboriginal people.
Yes.
Now, you recall those sections of your statement?
I do.
Can you just explain to the commissioners your understanding of the changing housing needs?
Yeah. So up until about 3 weeks ago, I was on the board of Aboriginal Housing Victoria for a period of 9 years. My term expired. It's a 9-year limit. One of the things which we had, or clearly influenced us as Aboriginal Housing Victoria in the housing we provided, in the things we developed, was the demand that people wanted in terms of housing. Our biggest housing request was for 1 and 2 bedroom units, townhouses, those type of things, which at the time when we really started to analyse it, or when you see the change over time, it has a distinct move away from people wanting 4 or 5 bedroom houses for large families. Most of our housing requests was from either older people wanting to have a smaller unit for themselves, or indeed younger people who were just starting out, or indeed starting a family, but it was clear that they didn't want to have huge families. They were looking more at 2 children. And that was actually a significant thing for us, because given the size of the housing requirement on Aboriginal Housing Victoria, it actually starts to be an indicator of what's going on in the broader Aboriginal community. That's what we noticed, is that there has been a change in the Aboriginal community, particularly from younger people, about where they're going.
And did that mean that the Housing Office had to go through a change of its stock?
Yeah, we are turning over a lot of our stock, or they are turning over a lot of their stock now. Because a lot of it has become aged, it's become worn out, we actually were also, a lot of stock was transferred from the state of Victoria to our ownership over the past 8 years to Aboriginal Housing Victoria. But really it was turning over stock that was no longer applicable or desired, or in locations that were no longer where Aboriginal populations were, to the type of housing where it is needed, addressing the needs of the clientele who came to us.
And then how does that affect the ability of the community to pick up kinship care and foster caring needs?
It follows that if people have smaller housing and are unable to take more than, if they're in 1 or 2 bedroom units, maybe even the occasional 3 bedroom house, their housing capacity is quite limited. And that did occur to me that therefore has a flow-on effect to, can people take in others in times of need for an extended period of time? I'm sure no matter what the size is, for a very short term in an urgent response, of course it's always possible to do that. Everyone does it. But as an extended long period of time, permanent, semi-permanent or permanent arrangement, it seemed to reflect that there was a much reduced capacity and ability to do that.
You've also, in your statement, set out some views you have about people's changing socio-economic status and that effect on the ability or willingness to engage in kinship care.
I do, and I say that as I've seen so much, or a lot of what I do now is in the economic space. I see more Aboriginal people engaged in the economy, particularly younger people. I see more Aboriginal people, quite rightly, having aspirations that the rest of Australia takes for granted. that not only has a changed economic outlook, but also has a changed social outlook for us as a community too. And it comes to the point where perhaps people are doing okay, and in particular their children may be doing okay. And the question then arises, do they want to disrupt their children doing okay by bringing in extended family who are not doing okay? And what will that do to their children? When you consider some of those people who may be parents, may have been brought up in those circumstances of disruption, do I want to bring my own children, or do I want to expose my children to perhaps the same circumstances? And the answer is maybe not.
Is it fair to surmise that people have in this generation something to lose, whereas their parents might not have had much? That would be a very astute observation, that previous generations, we were at the bottom of the pile. All we had was each other, and we depended on each other. And to be brutally honest, not a lot to lose. Now that's changing, and people are making different decisions. They're not to say that they don't care, they don't have empathy, they don't have a desire to support the community, but they also take into account, where am I taking the next generation that I'm responsible to, particularly my own children? Am I prepared to compromise that for the sake of others? That's a real and live question. It's not a judgment of anyone. It's just a real and live question that I think we perhaps don't contemplate enough. When there is a growing rate of children going into out-of-home care, then are there any solutions that you've turned your mind to that might assist in ensuring that children are able to be kept within the Aboriginal community? I think we do have to look at two alternatives to what we have assumed is the best way or the only way, and that is immediate family kinship care. If there is simply A, too many children, and B, not enough people prepared to provide that care, we simply can't go down that path. So we do have to think about what are alternative models. But it's also thinking about how do Aboriginal children, what are the circumstances in Aboriginal children that Aboriginal children find themselves in to be at the attention of the state in the first place. I don't think we pay nearly enough attention to that. The focus is on when things go bad, what do we do, rather than what are the circumstances that lead to us getting to that point in the first place. And that goes back to not only early form supports or interventions, but what are the broader circumstances that children and families find themselves in to start to go down that slope to begin with. A further question arises from your observations about the changing demographics. If it's the case that there's a growing Aboriginal middle class, if I can call it working class or middle class, is it fair to assume that there might be a reduction in children in need because of socioeconomic circumstances, or can you not make that assumption? Well, I think you can make that assumption that if more people are rising up the socio-economic scale, the assumption would be that their children are also rising with them. However, that seems to run counter to the figures we see in the growing population of children in care. So there is something that's not quite matching there. So you're not aware of any data that would indicate whether it's simply a lag or some other anomaly? It could possibly be a lag. I'm not sure if it. No, I haven't seen any data. But if you apply a theoretical approach to it, you would assume if you lift up this group of people, then this group down here should diminish. That's theoretically what should happen. Yet that does not seem to be what's happening when you look at the amount of children going into out-of-home care.
Council, could I ask a question here? Just while we're talking about economic matters, I'm thinking of the committee. I think you were on the committee. I can't recall the name, Andrew Jacomos, and I know it was represented when we spoke to the interdepartmental committees. Could you
Victorian Aboriginal Economic Council.
That's the one.
Yep.
That's the one. Could you just tell us if you think that has made some difference and in what way, in the context of what we've been discussing?
Yep. I think the council itself is starting the journey of a real engagement of Aboriginal people in the economy. To date, if I go back to 2013, prior to that, the only engagement or thought by anyone of Aboriginal people in the economy was unemployed to employed, which is, in terms of economics, is not hard to do. There's lots of job programs that do that. The difficulty, or the harder part, but the more substantive part, is how do you lift people up the economic scale over a lifetime of employment where they have increasing incomes. That's what has been going on since 2013. And the council now is looking at, we have an established base now. The exponential growth of Aboriginal people in the small business sector has been huge. I mean, in the past 10 years, it's just beyond comprehension, and that's a good thing. The amount of our younger people who are now seeking employment, they don't talk about a job, they talk about a career. They talk about having that increasing income. So we are seeing those change in economic circumstances. The council's next iteration, or what we're working on now, and we launched an Aboriginal economic strategy this year, I think it was. That's about how do we spend the next 10 years growing Aboriginal participation in the economy, because a simple fact of life is if you are economically doing well, a lot of your social ills shrink.
Is that growth in both professional careers and higher education being reflected in the census data?
The census data hasn't been analysed to that extent, but I have seen data which represents more Aboriginal people in business, more Aboriginal people in employment. The one I'm really interested in, though, is the movement of where they are on their income scales, where they are on their employment scale, for example, employment journey.
The longitudinal thing.
That's the really longitudinal stuff. The problem with snapshot data, it only tells you at that day. It's really the long-term stuff.
Continuing on the economic vein, is there any observation you can make about the impact of the Indigenous procurement policies that exist at both state and federal levels on that small business growth and the economic growth generally?
Yeah, so those procurement targets have had their desired effect, are having their desired effect. That is to encourage Aboriginal people into business. Now, the reason they work is traditionally Aboriginal people are the most overtrained people in Australia. I mean, that's just a fact which I don't need to go into. Plenty of evidence of that. The problem was, and again with business, Aboriginal people being encouraged to go into business, the problem was no market. That was the issue. There was no market for Aboriginal people in business. So we had to create one. Hence, by getting governments to adopt procurement targets, all of a sudden you have a market. Government departments falling over themselves to find Aboriginal suppliers. Now, in the beginning, there basically wasn't any, and now you see people being attracted to that. How it works or why it works, the targets set for governments, federal and state, around procurement were never designed to be met. They were never designed to be achieved. Not until you had a quantum so large that if they then went away, those targets, it wouldn't make a difference to the Aboriginal economic participation. Their job was to get it big enough so that an Aboriginal economy could exist in its own right, or Aboriginal economic participation would exist in its own right. So they have had a huge effect. Just if you look at the number of registered businesses in Victoria that run by Aboriginal people, owned and operated and run, that has exponentially grown over the past few years. It's a good outcome.
And has that movement of people into the private sector had any discernible effect on the people available to work in the public sector or the community sector?
Yes, it has. People moving into the private sector, both as not only business owners but as employees as well. It has meant, and this is not a bad thing, that people's opportunities aren't restricted to either the not-for-profit sector or government. That's actually a good thing. My own view, and I say this as somebody who was in government for over 32 years, the relationship between government and the Aboriginal community per se was far too close. Now, if we are helping helping to move towards the same relationship that non-Aboriginal people have with government, that is a good thing. And if through participation in the private sector that's happening, that's a good thing. We are not reliant on government. We are not dependent on government. Our relationship is normalised as the non-Aboriginal communities is.
Which brings me to the last section of your outline of evidence in relation to the need for capacity to be built in the Aboriginal sector to lead the work that needs to be done.
Yes.
Would you like to just address the Commission on that issue?
Yes, so in the Aboriginal community sector, there's a lot of work that needs to be done about simply building our capacity. When I look at the state of Victoria, and I think where we were in 2005, our relationship with government, where we were as a people, we have come an extraordinarily long way in an incredibly short period of time. In not even a generation, we have gone from where the Aboriginal community role was to sit and wait for government to come up with policies and programs that may or may not reflect what the need was, what the hopes and desires of the Aboriginal community were, notwithstanding governments and departments' attempts and genuine attempts to engage with Aboriginal communities. I look where we are now. In the space of less than a generation, we now have government policy primarily being driven by where the Aboriginal community wants to go in most things. We now have a situation where government is backing out of that. The problem with, I guess, the issue, though, that is still unresolved because of that complete change of the focus, and quite rightly, the Aboriginal community wanting to step up, to do things, to lead things, to respond to our needs rather than being government-led. That's a huge capacity leap that has to happen too. So while we've got the principle right, the capacity investment, the capability need hasn't been sufficiently addressed, sufficiently supported, or sufficiently understood. It's one thing to say, I can do this. It's another thing to look at yourself and say, and this is what I'm going to need to be able to do this. I think we've come such a long way so quickly, we haven't had time to take breath and take stock of what are the capabilities and capacities that we're going to need to be able to fulfil these things in the Aboriginal community controlled sector and all the things that flow in that sector, and indeed in Aboriginal people working in government as well.
Can I just follow on from that in relation to the training? You talk about ensuring that senior people have the right, are adequately supported and training. I've been out of the public service for 20 years, but I've been observing on the sidelines until, more recently. One thing I wondered about is whether or not we do need something a little bit different. I know some people, if they're able, they go and do a course, at a business school. Not everybody's able to do that. But I'm seeing particularly young men that I'm concerned about who wish to come into the public service at a more senior level, and they don't have the background in many cases. Is there the potential for something like a Harvard style, those short programs? We used to send public servants over there. Isn't there something that could be done in the space?
There's two things to it, Commissioner. One is there needs to be a greater focus on what people need in terms of training and education. The other one is just raw experience. Yes. The other one is just years of getting stuff under your belt, learning as you go on a graduated curve. One of my deep concerns that I have seen is younger people who are on an accelerated progression, where in the endeavours of agencies and government to have Aboriginal people in executive positions, some people have been promoted too far too quick, and they have not simply had the experience. They simply have not had the miles under the belt. They haven't been exposed to, as I said in my statement, the dark arts of the public service, to know how to get things done. to roll with the punches, the buttons to push, so forth. And they get in positions that, in my view, they're not ready for. And that's bad for two reasons. One, it's bad at the outcome for what their influence and capacity to make great change is. Two, it's enormously damaged to them as a person. I worry that in the enthusiasm, and look, as a matter of principle, of course I want to see more Aboriginal people at the most senior levels in government, not only in the Parliament but in the public service as well, but not at the cost of too far too quick, because that in fact set us back. That's my real worry.
Well, that's pretty much the concern I have. But there are some good people around who are strong culturally, not so strong in the appropriate ways that public service would want, and they do need something for a leg up. And if they do apply for something senior, there's been a spate of positions, as you know, at the moment, and their CV gets thrown in the bin because, they haven't got a qualification even in some cases, and that's embarrassing and hard for them to digest, really, as young men who've worked their way up in the world, not necessarily in the public service, though.
It's that qualified, and government is a unique beast. For anybody who's worked in the public sector, there is nothing quite like it, and you do have to go on a learning curve. I've seen Aboriginal and non-Aboriginal people come in from extraordinary careers in the private sector or outside of government. They come in at a high level, and the meat grinder spits them out in 6 months because it's a unique beast in itself. I worry that we don't invest enough time to get people the skills and capacities they need, not only through more formal education or setting them off on executive course and so forth, but giving them the career structure to learn the arts that they need to be a successful, long-term senior executive in the public service or in the Aboriginal executive ranks in the community sector as well, because that's becoming a far more complex sector in its own right.
Thank you, Anne.
Yes, to put it a little bit more bluntly, perhaps, the role of leadership within government is one which is very competitive at an interagency level, and people outside the government probably aren't aware how competitive it is. And people who come in underdone are less likely to be able to be competitive and therefore successful for their portfolio or agency. Would you agree with that?
I would say that people who don't understand it, you're absolutely right. It's a competitive space. It's competitive but cooperative. It can also be a very siloed space and lets you actively punch through the walls of the silos and try to make things happen horizontally instead of just vertically. Hence the question, or my response to a question you asked before, do we sufficiently understand the circumstances that Aboriginal children find themselves in to come to the attention of the state in terms of childcare? It's often looked at simply as a childcare issue, which almost implies the assumption is everything else is fine, it's just this one thing. That is in fact never the case. There's usually a whole bunch of things that if you tried to fit it into government agencies would be across a number of silos going on in a personal or family life. The trick with government is to try and look at that across horizontally, not simply vertically. And you try and do that with strategic policy. The Victorian Aboriginal Affairs Framework is built around that concept.
Thank you. Now, next to your outline are 5 documents. The Stolen Generations Reparations Steering Committee final report from 2021, the inquiry into the responses to the historical forced adoptions in Victoria, transcript, Annexure 3, the Healing Foundation submission to the Joint Select Committee on the implementation of the National Redress Scheme, Annexure 4, the Healing Foundation and AAG, ATSI AAG submission to the Royal Commission into Aboriginal Aged Care Quality and Safety, Stolen Generations, and Annexure 5, Connecting Home and the Office of Public Advocate submission to the Royal Commission into Violence, Abuse, Neglect and Exploitation of People with a Disability. Commissioners, unless there are further questions of this witness, I would seek to tender the outline of evidence from Mr Ham together with the 5 annexures. Are there any other questions?
Can I ask one? Thank you. Actually, there are two. Unless I'm mistaken, your statement does not engage with the issue of Aboriginal control of the childcare system or with issues arising under the present Section 18 arrangements.
Correct.
Do you have views in relation to those matters, or have you intentionally kept out of that?
I have a view, but I'm not intimately engaged in the sector, but my view aligns with my wider view that we have come a very long way in a very short period of time. Mm-hmm. The transfer of responsibility from the state to the community sector is an extraordinarily good thing to happen. Mm-hmm. It goes with that whole ethos of we know what's best for our community. What I worry about is that transfer hasn't been sufficiently understood in what it actually meant, mm-hmm. and therefore have this community-controlled sector been given the resources, the capabilities and capacities it needs and freedoms it needs to be able to do that job so there's actually positive outcome for Aboriginal people. My worry is that has this transfer simply substituted the Aboriginal community sector for what the state previously did, and the outcome for children is still relatively the same. Yes. It wasn't designed that way, but by not understanding the full breadth of what we were doing or what was being undertaken, is that potentially the result?
Thank you. In paragraph 35 of your statement, you list 5 key questions through which one can analyse the deficiencies of the system. And I've noted those. I only want to ask you about the last one, which is to what degree is there black cladding of the policies of government around the child protection system? Could you just explain that a bit better so that I understand it?
Yep. Okay. So black cladding is a term that's probably used in the Aboriginal economic space more than anything, and it started to show up in the procurement area first, where it became, in the early days of it, there was companies that were being started that were joint partnerships, and I put that in inverted commas on purpose, where you would have one Aboriginal person who owned 50% of a company and a large multinational who owned the other 50%. Yeah. So it was quite clear that all was not what it seemed. Yeah. Fortunately, that's been dealt with. In this context, what I meant by that was, while a lot of the policies and strategies that have been launched are indeed sound, and look, to be honest, they have Aboriginal words on them and they've got artwork and their intent and purpose is quite good. How they practically roll out, how they practically apply to Joe Blogg's client officer in Upper Kambukna West, who's just getting on with his job for Department XYZ. Even though the Secretary signed it off, the Minister launched it, and we had a great celebration. How far does this go down the chain? That is a real problem.
I understand.
That you can see.
Thank you. Thank you. I appreciate it. Thank you, Councillor.
Thank you, Commissioners. I tender the statement and the annexures, Chair.
Thank you, Councillor.
And that concludes the evidence for this witness.
Thank you. Those documents will be allocated the next exhibit numbers. Thank you.
Thank you, Chair. That concludes the witnesses for today, and I thank the Commission for setting a longer day. These are very, very sometimes difficult piece of evidence that we hear, and it's important that we get to hear them. And the fact that you've been able to sit longer to hear Mr. Ham's evidence should be recorded. Thank you.
Thank you, Council. Thank you, Commissioners, and thank you, Ian, for accommodating our time table.